Is it clear now? Okay, perfect. So yesterday we initiated a discussion on national emergency. What is national emergency? Basically, there are provisions in the constitution called emergency provisions. Article 352 deals with national emergency, 356 deals with president's rule, Article 360 deals with financial emergency. And what these emergency provisions basically do, they convert our federal polity temporarily into a unitary polity, only for a temporary period, till there is a threat because of war, external aggression, or if there is a threat to the working of a constitution in a particular state. That is why we had these emergency provisions. And we discussed national emergency under Article 352 of the Constitution. What is national emergency? If the president is satisfied because of war or external aggression or armed rebellion, then the president can proclaim national emergency on the written advice of the cabinet. And once this national emergency is proclaimed, it can continue for 1 month, but within 1 month, both Lok Sabha as well as Rajya Sabha shall have to approve national emergency. If it is approved, it will continue for 6 months. Can it be extended further for another period of 6 months? But then both Lok Sabha as well as Rajya Sabha shall have to approve the continuance of national emergency by passing a resolution by special majority. Can it be extended further beyond a period of 6 months? Every time, if the government wants to extend national emergency, it has to get parliamentary approval. Get parliamentary approval by special majority, and national emergency will continue for another 6 months. There is no upper limit. But every time you have to extend, you have to continue with national emergency. For that, parliamentary approval is required. Clear? But this national emergency can be imposed either throughout the territory of India or in a particular state or in one part of that state. And the president can proclaim national emergency even in anticipation of war. War has not broken out, but we anticipate that war might break out. That in that situation, the president can proclaim national emergency even in anticipation of war or external aggression or armed rebellion. And then this national emergency can also be revoked. How national emergency can be revoked? President can revoke national emergency at any point in time on the advice of the cabinet. Or if either of the two houses they do not approve national emergency, it shall be revoked. Or the proclamation of national emergency is subject to judicial review. If the judiciary finds that there was no need to proclaim national emergency, then national emergency shall have to be revoked by the president on the judicial order. Or a special power is given to Lok Sabha under Article 352. If Lok Sabha is in session, then the speaker will be sent a notice by members of the Lok Sabha, 50 members of the Lok Sabha. Then there will be a discussion on national emergency. If a resolution is passed by simple majority, then the president shall revoke national emergency. That means a special power for the revocation of national emergency is given to the Lok Sabha. If Lok Sabha is not in session, then 50 members will write to the President of India, and the President shall convene a special session of Lok Sabha. And in that Lok Sabha session, if a resolution is passed by simple majority, where the members of the Lok Sabha say that there is no need to continue with national emergency, it is binding on the President to revoke national emergency. And then we saw some of the impact, some of the effects of national emergency. And the first major impact is on fundamental rights. Article 19 is automatically suspended, or should we say the enforcement of Article 19 is suspended automatically when the national emergency is imposed on the grounds of war or external aggression. And then other fundamental rights can also be suspended, or their enforcement can be suspended if the president issues an order under Article 359. Under Article 359, all other fundamental rights can be suspended except Article 20 and 21. Clear? And then there is an impact on the state legislature, there is an impact on state executive. We say state executive comes under the control of the central government. Any directive which is issued to the states during national emergency becomes binding on that state. And if the state violates those directives, then that state government can be dismissed. And the impact on the state legislature is such that parliament assumes the power to legislate on state list as well. Normally, parliament cannot legislate on a state list because there is distribution of powers in a federal polity: union list, state list, concurrent list. Parliament has the power to make a law on union list and concurrent list. State legislatures have the power to make law on state list. But what do these emergency provisions do? They convert our federal polity into a unitary polity. And once it is converted into a unitary polity, that means during national emergency, Parliament can make a law, can legislate on any item which is mentioned in the state list. And in fact, during national emergency, state legislature is not dissolved. State legislature, state executive is not dissolved. In fact, the term of the state legislature, in fact, the term of the Lok Sabha can be extended for 1 year. National emergency continues, the term can be extended beyond 1 year as well. Why? Because in such a situation, we can't organize elections when there is war, when there is external aggression, when there is armed rebellion. Clear? Then something else. We say, and this is relevant for your mains examination now, how 44th Constitutional Amendment Act 1978, it has basically prevented the misuse of Article 368. Just like we discussed, how Keshavananda Bharati judgment of 1973 has saved India's democracy. In the similar fashion, we can say 44th Amendment of 1978 has prevented the abuse, the misuse of Article 352 of the Constitution. Because when national emergency was imposed in 1962, there was a genuine need to impose national emergency. Why? Because there was a war. When national emergency was imposed in 1971, it was a genuine need because there was a war between India and Pakistan, which led to emergence of Bangladesh as an independent country. But what happened in 1975? In 1975, emergency was proclaimed by the President of India on the grounds of internal disturbance. But what is this internal disturbance? War, we are clear. When a country declares war on India, we are in a state of war. So war is genuine. Armed rebellion, or for example, external aggression. There are external enemies who are launching an aggression against India. That much is clear. But what is this internal disturbance? This is a very vague term. Anything and everything can be deemed as internal disturbance. And when it is so vague, it is liable to be misused. And it was misused in 1975. And for that, I have given you the background as well, but I will repeat that background. 1971, Lok Sabha elections were held. Srimati Indira Gandhi contested elections from the Rai Bareilly constituency. Her opponent, Raj Narayan, lost the election. But then Raj Narayan approached the Allahabad High Court and asked the Allahabad High Court to disqualify the Prime Minister. Why disqualify Prime Minister? On the grounds of electoral malpractice. Because she has been using and misusing the government machinery for campaigning in the elections. She has been using the government resources, government vehicles, government employees to canvass for her, to campaign for her. This is an electoral malpractice under the Representation of the People Act, and as such, somebody who indulges in electoral malpractice should be disqualified. Allahabad High Court said, Prime Minister, you are disqualified. Srimati Gandhi then approached the Supreme Court, and the Supreme Court imposed a stay on the Allahabad High Court order, but said, Madam Gandhi, you can continue as the Prime Minister, but you won't have a right to vote inside Lok Sabha. So she became the first Prime Minister to have been disqualified by a High Court, the first Prime Minister to have been stopped from voting in Lok Sabha, although she was allowed to continue as the Prime Minister. And the very next day, she imposed national emergency on the grounds of internal disturbance. It is argued that during this period, a movement was launched by the students in Gujarat asking for less fee in government schools, educational institutions, and government colleges. Then this movement traveled to Bihar. And in Bihar, a charismatic old man, JP, Jay Prakash Narayan, who was the follower of Mahatma Gandhi, he started a movement known as Sampurna Kranti, complete revolution. And this complete revolution against corruption will end only if Indira Gandhi is removed as the Prime Minister. All these protests, Sampurna Kranti led by JP, student protests participating in Gujarat, all these were deemed as internal disturbance. So there is an internal disturbance going on in this country. On this ground, the Prime Minister asked the President proclaim national emergency. And at that time, there was this one common term which was used known as foreign hand. What is this foreign hand? Whenever somebody would criticize Indira Gandhi, whenever there would be protests against her government, she would accuse that these protests are not from the people of this country. These protests have been fueled, have been funded and supported by a foreign country, foreign hand. And that foreign hand was that of CIA, Central Intelligence Agency of the United States of America. So any criticism directed at her, she would shot back and say, there is a foreign hand behind this. CIA is responsible. They want to destabilize my government. And then, according to her, there was this internal disturbance. And then what she does, she picks the telephone, orally calls and talks to the President of India. According to some reports, the President was having a shower. He was in his bathtub. An advice was given, an oral advice was given by the Prime Minister without consulting her cabinet colleagues. An oral advice to the Prime Minister given to the President of India led to the proclamation of emergency on the grounds of internal disturbance. And this emergency continued for 2 years till 1977. And during this period, some of the horrific human rights violations were committed. Draconian laws were passed. All those who would oppose the Prime Minister, be it the opposition leader, be it the trade union leaders, be it the student activists, be it the journalists who were critical of Srimati Gandhi, they were arrested and detained under draconian laws such as MISA, Maintenance of Internal Security Act. And we have discussed one of the black spots on India's judiciary, a case known as ADM Jabalpur. ADM Jabalpur versus Shivakant Shukla, 1976. A 5-judge bench of the Supreme Court had to decide whether during national emergency, even Article 32 is to be stopped from enforceability. Can you not approach the Supreme Court under Article 32 of the Constitution if your right to life has been violated? If a law has been passed by the Parliament, a criminal law, and it has been given retrospective effect, can it happen during national emergency? And 4 judges of the Supreme Court said, yes, it can happen because we are in a state of emergency. And only 1 judge disagreed. Justice Khanna. Justice Khanna was later all set to be appointed as the Chief Justice of India because he was the senior most judge of the Supreme Court. But he was superseded. And instead, Justice Beg was appointed as the Chief Justice of India. And Justice Khanna resigned in protest. During this national emergency, lot of human rights violations, as I said, were committed. And then in 1977, when Janata Party came to power, Janata Party promised the people of India that we will make changes to the constitution. We will ensure that such a situation will not arise in the future. Such blatant misuse of our constitution will not take place. And they lived up to that promise. And in 1978, the parliament enacted a law, amended the constitution, 44th Constitutional Amendment Act 1978, which has prevented the misuse, the abuse of Article 352. What are these changes which were made in 1978, which has prevented the misuse of Article 352? Number one, previously, national emergency could have been imposed by the President of India on the basis of the oral advice of the Prime Minister. Now, this oral advice has been replaced by written advice of the Cabinet. It was argued that when national emergency was proclaimed by the President of India in 1975 on the advice of the Prime Minister, on the oral communication of the Prime Minister, the very next morning, the Prime Minister is calling a cabinet meeting. And in that cabinet meeting, she is informing the ministers that national emergency has been imposed. But we are a parliamentary democracy where Prime Minister is a very important figure, but Prime Minister alone cannot take a decision. Prime Minister has to consult the cabinet colleagues. Any decision of the cabinet has to be communicated to the president, not the oral advice of the Prime Minister. And that is how this misuse was prevented. Now, if national emergency is to be imposed, it can be done only on the written advice of the cabinet, not on the advice of the Prime Minister alone. Second, this term, internal disturbance, which is very vague and liable for misuse, this term, internal disturbance, was replaced by armed rebellion. That means now the president cannot proclaim national emergency on the grounds of internal disturbance. He can proclaim or she can proclaim national emergency on the armed rebellion. If there is a rebellion from within the country where people are raising arms and they want to overthrow the government of India or they want to destabilize the government because of that armed rebellion, then the president can proclaim national emergency. Third, previously, national emergency, if it was imposed, proclaimed, national emergency would have continued till it was revoked by the president. National emergency is imposed, it will continue till the time it is revoked by the President of India. That means there is no upper limit. Now, this national emergency will continue for 6 months. Can it be extended further for another 6 months? Can it be extended further for another 6 months? But every 6 months, Parliament has to approve the continuance of national emergency. And that is what we call periodic parliamentary control. After every period, Parliament will exercise a control on national emergency's continuance. Every period is that of 6 months. Because previously, if national emergency was proclaimed by the president, it was approved by both houses of the parliament, then Parliament's job is over. Then unless and until the president revokes national emergency on the advice of the Prime Minister, national emergency would have continued. Now, to ensure Parliament exercises control over the continuance of national emergency, every 6 months, the government will have to ask the Parliament to approve the continuance of national emergency. Previously, national emergency could have been proclaimed and approved by Parliament by simple majority, just simple majority, members present and voting. Now, this simple majority was replaced by special majority. basically a slightly tougher majority to obtain. Unless and until there are genuine reasons to proclaim national emergency, Parliament will not approve. Previously, national emergency could have been approved by both houses of the Parliament within 2 months of its proclamation. National emergency is proclaimed today. Within 2 months, it has to be approved by both Lok Sabha as well as Rajya Sabha by simple majority. Now, this 2 month has been replaced with 1 month. Now, within 1 month of the proclamation of national emergency, both Lok Sabha as well as Rajya Sabha shall have to approve national emergency by passing a resolution by special majority. So 2 months ratification has now been reduced to 1 month ratification. Sixth, a special power given to Lok Sabha, which was not previously part of the Constitution. Under Article 352, Clause 8, if 50 members of Lok Sabha write to the Speaker or the President, there has to be a special session of Lok Sabha. And if Lok Sabha passes a resolution by simple majority to disallow the continuance of national emergency, the President shall revoke national emergency. Previously, all fundamental rights could have been suspended. When national emergency is imposed, all fundamental rights could have been suspended. Now, all fundamental rights can be suspended except Article 20 and 21. That means these were the changes which were made in the year 1978 through 44th Constitutional Amendment Act, which also gave the power to the judiciary that you can conduct judicial review if this national emergency is proclaimed on some irrelevant grounds. There was no need to proclaim national emergency. If judiciary thinks that national emergency was proclaimed for useless reasons, there was no need, no justification for it, it can be revoked on the orders of the judiciary. All these changes made by 44th Constitutional Amendment Act has prevented the misuse, the abuse, the overuse of Article 352 of the Constitution. And it is evident from the fact that the first time national emergency was misused was in 1975. And that also happens to be last time when it was misused. Because after 1975, national emergency has not been imposed, which means this 44th Amendment has prevented the abuse, the misuse, the overuse of Article 352 of the Constitution. And listen to me carefully. When, for example, national emergency is proclaimed in one part of the territory of India, for example, national emergency is proclaimed in Rajasthan. Why? Because Rajasthan also borders Pakistan. Maybe Pakistan has now tried to attack India through the Rajasthan border. And then Parliament becomes empowered to make a law on Rajasthan as well, on all the items which are mentioned in the state list for Rajasthan. But can Parliament make a law on any other state as well, apart from the state where national emergency was imposed? Which means during national emergency, since national emergency can be imposed in the entire country or any state or any part of that state, does that mean when national emergency is proclaimed, Parliament can make a law only on the state list of Rajasthan? Only for Rajasthan it can make the law? No. Parliament can make a law on any other state as well if it is relevant. Relevant in the sense, Parliament can make a law on state list in Gujarat as well. Why? Because Gujarat and Rajasthan, they border each other. Maybe for Punjab as well. Maybe for Jammu and Kashmir as well. Why? Because this national emergency, which is imposed in Rajasthan, the laws can be made by the Parliament for other state as well, other than that state in which this national emergency has been proclaimed. Directives can be issued not only to the Rajasthan government, can be issued to the Gujarat government as well by the central government. That since in Rajasthan national emergency has been imposed, you are also bound by the directive that we are giving you. That is an important point that can be relevant for your prelims examination. And that completes our discussion on national emergency. Any questions? Let me know. Every time Parliament has to approve national emergency, it has to pass a resolution by special majority. Does judiciary work during emergency? Yes. Article 32, we have discussed in fundamental rights. The moment your fundamental rights are violated, you can approach the Supreme Court under Article 32. Article 32 is suspended. Enforcement of Article 32 is suspended for other fundamental rights. For example, you cannot approach Supreme Court under Article 32 if Article 19, if Article 18, if Article 17, if Article 14, if Article 15 has been violated. But you can approach the Supreme Court under Article 32 if Article 20 or 21 is violated. That is why we say Article 19 or fundamental rights are not suspended. Their enforcement is suspended, which basically means you can't approach the court under Article 32 except if Article 20 and 21 is violated. So Lakshmikant says fundamental rights under Article 19 cannot be suspended during armed rebellion or internal aggression. Article 19 is not automatically suspended when national emergency is imposed on the grounds of armed rebellion, but it can be suspended if the president issues an order under Article 359, and that's something we have discussed yesterday. Will parliament session take place during national emergency? My dear, apply logic. What did I say? I say that Lok Sabha during national emergency, its term can be extended by 1 year at a time, which means Lok Sabha continues. What did I say? That parliament can make a law on state list during national emergency, which means parliament is functioning. All these changes were for all kinds of emergencies, whether war or external aggression or armed rebellion. Okay. Now let's look at Article 356 of the Constitution, President's Rule. When this provision of the Constitution was being debated in the Constituent Assembly, Dr. B.R. Ambedkar, he said, I am sure that this Article 356 will not be used in independent India, and that this Article 356 would remain a dead letter. Although we need Article 356, but I'm sure in the independent India, Article 356 will not be invoked, Article 356 will not be used, it will remain a dead letter in the Constitution. That means although it will be part of the Constitution, but it will be never used, which means it is as if it is dead. Basically, Dr. Ambedkar had a hope that Article 356 will not be used in independent India. But the most used, abused, overused provision of the Constitution is Article 356. And more than 110 times, Article 356 has been imposed. According to various statistics, more than 114 times Article 356 has been invoked. And what is this Article 356? Long story short, in simple terms, during Article 356, when president's rule is imposed in a state, there is no state government. State government is dismissed. Which means who will act as the state government? The central government. That means this state will be kept under the control of the center. You can assume that during president's rule, this state is like a union territory, directly under the control of the center. And the legislature also is not functioning. We will discuss that initially, legislature is suspended. That's what we call suspended animation. Over a period of time, legislature is dissolved, which means now there is no legislature. Even when the legislature is suspended, who makes law for that state? Parliament. That's exactly what happens with a union territory as well. Union territories are directly controlled by the center. For union territories, laws are made by the center, which means the Parliament of India. That means when a state is converted and president's rule is imposed in that state, For that particular state, we can say it is as if it is a union territory, which means converting our federal polity into a unitary polity, but for some time, for a temporary period. And what is the rationale for that? For that, we need to understand Article 355, because Article 355 imposes a duty on the union, imposes a duty on the central government. It is as if that there are two siblings, elder sister and younger brother. The parents, they have to send both these children to school, telling the elder sister, take care of your brother. Don't allow him to eat ice cream. Why? Because he's suffering from throat infection. It is your duty. Protect him. Protect him from the dogs. Unfortunately, what happened in Hyderabad? A 4-year-old boy was mauled by the dogs. But be that as it may, it shall be the duty on the union, imposed by the constitution, a duty on the union, that what you have to do, you have to protect every state in India from external aggression. That means if Pakistan is attacking Rajasthan, it shall be the duty of union to protect Rajasthan, to ensure unity, integrity, and sovereignty of India. And at the same time, if any state, in any state, constitution is getting violated, and that is what we call breakdown of constitutional machinery. In any state, if there is breakdown of constitutional machinery, the union government will have to step in, because it shall be the duty of the state. And I will explain what is this phrase, breakdown of constitutional machinery. It shall be the duty of the union that you have to protect every state from external aggression. And you have to protect that every state is protected from internal disturbance as well. And you have to ensure, it shall be your duty, that every state will be carried out according to the provisions of the constitution. That means in no state constitution is getting violated. That's the duty of the state. That's the duty of the union to ensure. And for that, we have Article 356 of the Constitution. And what is Article 356? If the president is satisfied again, I don't have to reiterate, it's not the personal satisfaction of the president, it's the satisfaction of the cabinet. If the president is satisfied, how? On the basis of the report of the governor or even otherwise. And I will tell you what is this or even otherwise. If the president is satisfied on the basis of the report of the governor or even otherwise, what satisfaction? That there is a breakdown of constitutional machinery. Then what the president can do? President will proclaim. What will the president proclaim? President's rule. Under Article 356 of the Constitution. Constitution says it shall be the duty of the union to protect a state from external aggression, from internal disturbance. And at the same time, it shall be the duty of the union to ensure that in every state, the governance is being carried out according to the constitution, which means in no state is the constitution getting violated. And for that, Article 356 says, if the president is satisfied. Now, what will satisfy the president? Either a governor's report or even otherwise. What will be mentioned in this governor's report? That there is a breakdown of constitutional machinery in a state. Then what the president will do? President will proclaim president's rule under Article 356 of the Constitution. But what is this governor's report? When governor sends this report, the governor is basically acting in his discretion. Because why would a chief minister and his council of ministers advise the governor that please tell the president that in our state there is breakdown of constitutional machinery, dismiss us and impose president's rule? While recommending president's rule, the governor is acting in his discretion, not on the advice of the chief minister and his council of ministers, and basically telling the president that there is no government possible right now. For example, Maharashtra elections. Elections were held. BJP emerged as the single largest party. Along with the Shiv Sena, they had to form the government, but Shiv Sena said, make us the chief minister. Now, no government was possible. The governor asked the leader of the BJP, Devendra Fadnavis, can you form the government? He said, I don't have the majority. Shiv Sena, can you form the government? I don't have the majority. NCP, can you form the government? I will get back to you. Congress, no, I will not go there. Governor advised the president, submits a report that there is breakdown of constitutional machinery. Why? Because no government is possible. Constitution says there shall be council of ministers headed by the chief minister to aid and advise the president. If there is no chief minister possible, there is no council of ministers possible. What is this? This is breakdown of constitutional machinery. And what the governor did in his report, submitted this report to the president and said, please proclaim president's rule. President looked at this report, President Ramnath Kovind, and he told the governor, Governor Koshari, see, I don't have this power. Although Constitution says under Article 356, if I'm satisfied, Governor says, sir, I know such provisions are there for me as well. Please refer this matter to the central government, to the cabinet. President picked this report, sent it to the cabinet. Cabinet then looked at breakdown of constitutional machinery and gave an advice to the president. Please proclaim president's rule. And once the president's rule was proclaimed, the state of Maharashtra came under the central rule. That means during this president's rule, who will be the government of Maharashtra? Central government. President through his officer, who is the governor. Who will make laws for Maharashtra during president's rule? Parliament, because now Parliament is the legislature for the state of Maharashtra, because they don't have a legislature. If the president is satisfied on the report of the governor, or even otherwise, and what is this or even otherwise? Karunanidhi's government in Tamil Nadu was dismissed. President's rule was imposed even without a governor's report. Does that mean governor's report is necessary for the president to proclaim president's rule? No. Constitution says if the president is satisfied on the report of the governor or even otherwise. What is this or even otherwise? Maybe there is intelligence report. Maybe there is IB report. Maybe there is RAW report. Maybe there is report from the state crime branch. Whatever the report is, if these reports to the president suggest that there is breakdown of constitutional machinery in a state, president's rule can be imposed in that state. Article 356, if the president is satisfied on the report of the governor or even otherwise, which means the report of the governor is not mandatory, is not necessary condition. Even without a governor's report or even otherwise, the president, if he is satisfied that in this state there is breakdown of constitutional machinery, president can proclaim president's rule. And how long will this president's rule continue? President's rule, once it is proclaimed, continues for 2 months. But within 2 months, both Lok Sabha as well as Rajya Sabha, they have to approve president's rule by a resolution. And this resolution is to be passed by simple majority. And once it is approved by both houses of the parliament, president's rule continues for 6 months. Can it be extended further? Yes. Again, both Lok Sabha as well as Rajya Sabha, they have to pass a resolution approving president's rule for that state for another 6 months. Can it continue after that? No. Which means what is the validity of president's rule? 1 year. But president's rule can be continued for another 2 years. Every time for 6 months. That means 6 months, then extension, then extension, then extension, total 2 years. But for that, either of the two conditions should be satisfied. Either national emergency is proclaimed throughout India or any part of that state, or the Election Commission should certify that it is not possible to hold elections. What does that mean? Listen to me carefully. Article 356, it says if the president is satisfied on the report of the governor or even otherwise. What satisfies the president? That there is breakdown of constitutional machinery in a state. If the president is satisfied, he will send the matter to the cabinet. Cabinet will give an advice, and whatever advice is given by the cabinet, that's binding on the president. If the cabinet says proclaim the president's rule will be proclaimed in that state. But for how long will this president's rule continue? This president's rule, after it is proclaimed, within 2 months of its proclamation. For national emergency, it is 1 month. Within 1 month of its proclamation. For president's rule, within 2 months of its proclamation, both Lok Sabha as well as Rajya Sabha separately, they have to approve president's rule by passing a resolution by simple majority. For national emergency, it is special majority. For president's rule, it is simple majority. And once it is approved, president's rule continues for 6 months. Can it be extended further for a further period of 6 months? Yes. Which means it can be extended for, president's rule can be imposed for 1 year. Can it continue after 1 year? No. It can continue beyond 1 year for a maximum period of 2 more years. But every time, 6 months at a time. 6 months, then 6 months approval, then 6 months approval, then 6 months approval. Only if either of the two conditions are satisfied. What are the conditions? Either national emergency has been imposed in the entire country or in that state or any part of that state. If it is, then national emergency, if it is imposed, during this period, president's rule for that state continues for 6 more months, 6 more months, 6 more months, 6 more months for a maximum period of 2 years. Or election commission should certify that in this situation, we cannot organize elections in that state. If either of these two conditions are satisfied, then the president's rule can continue for 2 more years, which means what is the maximum validity of president's rule? Maximum validity is 3 years. Maximum 3 years. Clear? But for Punjab, president's rule was imposed for first 3 years, then for 4th year as well, then for 5th year as well. How is that possible? Listen to me carefully. If the constitution itself says that the maximum validity of a president's rule is 3 years, 1 year for 6 months, beyond 1 year if either of the two conditions are satisfied, which means maximum validity of president's rule is 3 years, which means if you want to violate this limit, for that what you have to do? You have to amend the constitution. And for Punjab, constitution was amended because in Punjab there was a movement, Khalistani movement, where some members of the Punjabi society, they wanted a separate country for Sikhs known as Khalistan. And that is how Operation Blue Star was launched, when there were militants holed inside the holy temple, Golden Temple at Amritsar. Bindrawale, he was killed during that Operation Blue Star. When RB was launched, when they entered the Golden Temple, the sacred Golden Temple, which also impacted the Akal Takht, the sacred Takht inside the Golden Temple. But be that as it may, there was militancy in Punjab, and in that situation, it was not possible to organize elections. Then what happened? president's rule was to be continued for beyond a period of 3 years. For that, constitution was amended. That 3 years for Punjab means 4 years. When the condition was still not suitable for organizing elections, another constitutional amendment was made. For Punjab, 4 years means 5 years. Which means every time, if the constitution says, it's very simple to understand. If the constitution says maximum validity is 3 years, but you have to go beyond the constitution, for that what you have to do, you have to amend the constitution. And constitution was amended. 3 years for Punjab means 4 years. 3 years for Punjab means 5 years. And that is how twice constitution was amended to extend president's rule in case of Punjab beyond the constitutionally mandated 3-year term. Is that clear? So this is how the president's rule, on what grounds it is proclaimed, and for how long it will continue. It will continue for 6 months, then for 6 months. That means maximum for 1 year. In normal circumstances, only for 1 year. Now, if either of the two conditions are satisfied, it can be extended for 2 more years, but every time only for 6 months. For 6 months, then give approval by simple majority for another 6 months, another 6 months, another 6 months, which means the maximum validity of president's rule is 3 years. And if you want to go beyond 3 years, for that you will have to amend the constitution. Clear? If this is how president's rule is imposed, how can it be revoked? How can it be revoked? This is where your Lakshmikant is wrong. When Lakshmikant in a table differentiates between national emergency and president's rule, it makes a mistake. It says national emergency can be revoked on the advice of the government, but president's rule can be revoked at any point in time by the president. That is not possible. It can be revoked at any time by president, yes, but only on the advice of cabinet. President's rule is imposed today, it can be revoked tomorrow on the written advice of the cabinet. Or if either of the two houses do not approve president's rule, or if judicial order calls for revocation. Because president's rule also is subject to judicial review. If the judiciary feels that president's rule was imposed incorrectly, there was no need to impose president's rule, it can be revoked. That means on judicial order, it can be revoked. It can be revoked at any point in time by the president on the advice of the cabinet. It can be revoked if either of the two houses do not approve the continuance of president's rule. But something happened in Maharashtra. What happened in Maharashtra? Listen to me carefully. No government was possible. Governor sent a report to the president. President, on the advice of the cabinet, proclaimed president's rule in Maharashtra. But now there were 3 political parties who were trying to come together: Shiv Sena, NCP, Congress. And they almost sealed the deal. Late night, late evening, there was a press conference where it was announced Uddhav Thackeray will become the chief minister. I was very happy. I also slept, because tomorrow now Uddhav Thackeray and others, they will go to the governor with a letter that, see, we have the majority, invite us, we are ready to form the government. Uddhav Thackeray was also sleeping, I was also sleeping. And when I woke up, chief minister was appointed. Who was the chief minister? Devendra Fadnavis. Who was the deputy chief minister? Ajit Pawar. I called Uddhav Thackeray. There is a chief minister. It's a fictional story. Somebody would have called Uddhav Thackeray. My dear, what are you doing? I'm having a peaceful sleep because today I'll go and meet the governor at Raj Bhavan. I have to stake claim to form the government. Devendra Fadnavis has been appointed. How's that possible? Appointed by the governor. But the state is under president's rule. It was revoked. How can it be revoked when there is no cabinet meeting? When did Prime Minister call the cabinet meeting? Without cabinet meeting, the governor, the president, revoked president's rule. But how is that possible? It's possible because there are rules which allow the Prime Minister to deviate from these rules. Prime Minister had to go abroad or somewhere. And then there was no time because it was midnight. There was no time to call the cabinet meeting because all the ministers would also be sleeping, and it would not look proper to knock at their door and say, come, there's a cabinet meeting. There was no cabinet meeting possible. President orally advised the Prime Minister orally advised the president, please revoke national president's rule in Maharashtra. He said, but I need written advice from the cabinet. He said, there is no need for written advice because according to the rules, I can deviate from the rules as well if there is a situation. And the situation is such that we have a government possible in Maharashtra. I'm telling you, you are bound by my advice. Please revoke president's rule. Sir, as you say. And in the midnight, 5 o'clock in the morning, the president's rule was revoked by the president. Ministers were sleeping, but president was kept awake. Issued an order that president's rule is revoked in Maharashtra. And early morning, Devendra Fadnavis and Ajit Pawar were sworn in as the chief minister and the deputy chief minister of Maharashtra. But then since they did not have the majority, ultimately they had to resign in less than 2 days. And then Shri Uddhav Thackeray became the chief minister. But the point is, president's rule can be revoked, not at any point in time by the president as mentioned in Lakshmikant, only on the advice of the cabinet. But it can be that there are some rules which allow the prime minister to deviate because of some urgent needs when cabinet meeting is not possible. Then prime minister advised the president, revoked president's rule, he revoked the president's rule, and ultimately the government was possible. Clear? Okay. But what exactly happens during president's rule? You would know that, but let's recap as well. President, when he or she proclaims a president's rule in a state, through this proclamation, through this order, she will assume to himself or herself any function of the government of the state, all powers vested with the governor or any body other than the legislature of that state. What does that mean? That means if the power, all the executive powers are with the governor, acting on the advice of the chief minister and council of ministers. The first casualty when president's rule is imposed, proclaimed, chief minister and his council of ministers are gone. That means the first casualty is dismissal of chief minister and council of ministers. But all the powers were with the governor, acting on the advice of the chief minister and council of ministers. Now, when the president proclaims president's rule, all these executive powers are now with the president of India. All the powers except the powers of the legislature of that state. But who will get the powers of the legislature of that state? Legislature will become the parliament. Declare that the powers of the legislature shall be exercisable by or under the control of the parliament. What does that mean? There are two things: executive, legislature. Executive is governor, chief minister, council of ministers. President's rule is proclaimed. Chief minister, council of ministers dismissed. Now there is this governor. All your powers are with the president. You will only take these powers, but you are now my agent. Because previously you were acting on your own. I was appointing you, but you were acting on your own on the advice of the chief minister and council of ministers. Now you will function as the head of the government in that state, but you will act on my advice. Whatever I tell you, you have to abide by that. That means during president's rule, you become my agent. Clear? That's the first thing, executive. What about legislature? Legislature is kept under suspended animation. What is suspended animation? Legislature is not dissolved. legislature continues, but it is suspended. That means it will not function. When it will not function, it is not dissolved, it will be suspended. And during president's rule, who will make law for that state? Parliament. Or if parliament wants to give this responsibility to some other institution, parliament can do that. That is why we say president will say in his proclamation that the powers of the legislature of that state will be exercised by parliament, which means parliament will make laws for that state or under the control of the parliament. Maybe parliament will ask the governor to make rules, to make laws for that state. That can also happen. That means legislature is not dissolved. It is kept under suspended animation. That means giving opportunity. For example, Maharashtra Assembly was not dissolved. But during the time it was under president's rule, Maharashtra Legislative Assembly did not function. But once the government was possible, president's rule was revoked. The same Maharashtra Legislative Assembly, same MLAs, they got together, elected a chief minister. Shri Uddhav Thackeray became the chief minister. That means legislature is not suspended. Legislature is not dissolved. It's suspended. It's kept under suspended animation. That is what happens in a president's rule. But president's rule was used, overused, misused throughout its history. When Dr. Ambedkar said, I am sure that this provision of the constitution will remain a dead letter, it will not be used, it will not be invoked, he was wrong. And in fact, the most abused provision of the constitution is Article 356, which is the president's rule. What happened? 1977, when Janata Party came to power, Janata Party won the 1977 general elections and it swept the entire North India. In the entire North India, there were only 2 seats given to the Congress Party, only 2 victories, only 2 constituencies were won by the Congress Party. Otherwise, it was swept away by the Janata Party. When Janata Party came to power, they had a president as well. Janata Party Prime Minister and the cabinet advised the president that there are these Congress governments in various states in North India. Said, yes, dismiss them. What? Impose president's rule, dismiss them, dissolve their legislative assembly, let's have fresh elections. Why? Because Congress has lost the 1977 general election. So what will their state governments do in these states? Because they have lost the confidence of the people. That's why I'm advising you, dismiss the state governments of all the Congress governments in the states, dismiss them, dissolve the legislative assembly, and we will have fresh elections. Because in 1977, if we won the Lok Sabha elections, if now there are state elections as well, we will win those elections as well. That is why we will have elections. Okay. All the Congress governments were dismissed, president's rule imposed, fresh elections were held. 1980, Indira Gandhi came back to power. Said, President, come here. What? All these Janata Party governments in states, dismiss them, dissolve their legislative assembly, let's have fresh elections. Madam, why? Why? Because they have lost the confidence. Confidence of the people. Now people have elected us. Just like what they did in 1977, we are doing it now. Please. My advice is binding on you. Sure, madam. Dismissed, dissolved, fresh elections. Something else happened. Babri Masjid was demolished in 1992, and then there were communal riots in different parts of the country. Particularly severe were the riots in Madhya Pradesh. Madhya Pradesh government was not in a position to control these riots. What the cabinet, the central government asked the president, please dismiss Madhya Pradesh government. Why? Impose president's rule. Why? Because they are unable to control the riots, curb the riots, communal riots in the state of Madhya Pradesh. This proclamation of president's rule in Madhya Pradesh went to the Supreme Court. Not just this, Nagaland also, for some corruption reasons, the president dismissed the Nagaland government, dissolved the legislative assembly, president's rule was imposed. Nagaland case also went to the court. And the curious case was that of S.R. Bommai, which we have discussed briefly yesterday. S.R. Bommai versus Union of India, 1994. If Keshavananda Bharati judgment has saved India's democracy, if 44th Constitutional Amendment Act 1978 has prevented the misuse, abuse, overuse of Article 352 of the Constitution, it is the landmark judgment of the Supreme Court in 1994, known as S.R. Bommai judgment, which has prevented the misuse, the overuse, the abuse of Article 356 of the Constitution. S.R. Bommai was the chief minister of the Janata Party. The state of Karnataka, he belonged to the Janata Party. Governor asked Mr. S.R. Bommai, come meet me at Raj Bhavan. You are dismissed. S.R. Bommai asked, why? Because we have received some letters of some MLAs who were supporting you, close to 12 MLAs who were supporting you. They have withdrawn their support to you, which means your government is in a minority. You don't have the majority on the floor of the Legislative Assembly. Sir, but at least 9 of those MLAs I have spoken to, they have said that this letter is fake. It's forged. They have never written this letter. I said, no, I've got the letters. You don't have the majority in Legislative Assembly. You are dismissed. I said, but give me the opportunity. I don't have to prove my majority in Raj Bhavan, in the lawns of Raj Bhavan. I have to prove majority on the floor of the Legislative Assembly. The governor, don't give me this gyan. You are dismissed. Fired. Governor sent a report to the president that there is breakdown of constitutional machinery in Karnataka because the MLAs who were supporting the Janata Party government, S.R. Bommai, they have withdrawn support. Now, since there is breakdown of constitutional machinery, impose president's rule, dismiss the government. And the president's rule was imposed. The government was dismissed. S.R. Bommai approached the Supreme Court. If the president is satisfied on the report of the governor or even otherwise, that there is breakdown of constitutional machinery, but the point is, what is this breakdown of constitutional machinery? It has not been explained in the Constitution, defined in the Constitution. For Madhya Pradesh, breakdown of constitutional machinery is the government is unable to control the riots. For Nagaland, the breakdown of constitutional machinery is because there is corruption. For Tamil Nadu, the breakdown of constitutional machinery is because there is law and order problem. For Karnataka, the breakdown of constitutional machinery is that the chief minister seems to have prima facie lost the confidence of the Legislative Assembly. What is this breakdown of constitutional machinery? My lord, please tell us. S.R. Bommai versus Union of India. Supreme Court said, number one, federalism is part of the basic structure of Indian Constitution. The Supreme Court said there is a thin line between the center and the state, and this should not be crossed. There is a thin line of federalism, which is part of the basic structure of the Constitution. If the center at any point in time, based on its whims and fancies, invokes Article 356, dismisses a state government, then where is federalism in India? Where we say dual government, where we say distribution of powers. Federalism is part of the basic structure of Indian Constitution. And that is why today we will decide and we will tell you when you can impose president's rule. President's rule can be imposed only on the breakdown of constitutional machinery. Not on the basis of the breakdown of law and order. Law and order has been violated. There are protests in a particular state. For example, people are protesting that this political party came to power because they promised that we will give them pressure cookers, juicer, mixer, grinder, washing machine, refrigerator. That's what the Dravidian political parties do in Tamil Nadu. promise people juicer, mixer, grinder, television camera, television sets, refrigerators, golden coins, so on and so forth, buffaloes also in some cases. If you have failed to live up to your election promise as a political party, and then people are coming on roads protesting because you have been unable to fulfill your election promise, that is only breakdown of law and order. That's not the breakdown of constitutional machinery. To restore law and order, maybe more police is required, more paramilitary troops is required. But breakdown of law and order does not mean breakdown of constitutional machinery. That is the difference between the two. Madhya Pradesh government got happy. Madhya Pradesh previous chief minister said, "Thank you, my lord, you have saved me." Said, "Why?" Said, "My government was dismissed." When? After the Babri Masjid demolition, my government was dismissed. Please restore me as the chief minister of Madhya Pradesh. Why was it dismissed? Said there were riots because of Babri Masjid demolition. And then there were riots between the two communities, which basically means there is breakdown of law and order. That is how they dismissed my government. Restore me as the chief minister. Said, no, it was good that we were dismissed. Why? Because secularism is also part of the basic structure of Indian constitution. If there are rights, communal rights in a state, which the state is unable to control, which means secularism is getting violated in that state. Secularism violation is the breakdown of constitutional machinery, and on the grounds of the violation of secularism, president's rule can be imposed. Breakdown of law and order, if there is corruption in that country, in that state, if there are allegations of corruption against a minister, that cannot be the basis for the proclamation of president's rule. Just because in Nagaland there is a corruption allegation against a minister and the president dismissed the state government, imposed president's rule, that cannot happen. This is only a breakdown of law and order. This can only be a corruption case. It is not the breakdown of constitutional machinery. Then the government said, "Dear Supreme Court, you are all knowing, all powerful, with wisdom. Please tell us, where can we impose president's rule? Where can we not impose the president's rule?" Supreme Court said, "We will tell you what is a fit case of president's rule and what is an unfit case where you can't impose president's rule." Supreme Court said, if there is a hung assembly, with no political party capable of forming a government, this is a fit case of president's rule, because constitution says there shall be chief council of ministers headed by the chief minister to aid and advise the governor. When there is no chief minister possible, when there is no council of ministers possible, because it's a hung assembly, no political party has got the majority, no political party is in a position to form the government. This is a fit case of president's rule. Impose president's rule. We have no problem whatsoever. If the chief minister resigns and no other political party is capable of forming the government, there is a majority government in Gujarat, but the chief minister resigns. Now BJP says we are not in a position to form the government. We don't want to form the government. How can Congress form the government with few MLAs? This is a fit case of president's rule. Impose president's rule in Gujarat. Violation of union government directives under Article 365. What is Article 365? Yesterday I told you that there are some instances where the directives are issued by the central government and these directives are binding on the states. What are these directives? For example, a directive is issued by the central government to a state that there are national highways, there are means of national importance, roads of national importance, railways, for example, safeguard them. If the state is unable to safeguard railways, because railway belongs to central government, railway lines pass through various states. Now there is the state government which has blocked the railway line. For example, Tamil Nadu has blocked the railway line and railway cannot go and pass through Karnataka. What will happen in this case? Center will issue a directive to the state government under Article 365 of the Constitution. and the sanction behind this directive is coercive. Please unblock this railway line. This is a directive. This is binding on you. Don't do that, because these are means of national importance, railways. Unblock them. If the Tamil Nadu government fails to do that, does not abide by this directive, dismiss that state government, impose president's rule. This is a fit case of president's rule. Similarly, there is a national highway which is blocked by a state or blocked by the protesters in the state, and the state is unable to ask the people, to convince the people to unblock that national highway. Directive can come from the center under Article 365. That you have a directive under Article 365, please ensure that this national highway continues to function, to operate without any disturbance. If the state is unable to do that, dismiss that state government. This is a fit case of president's rule. If there are linguistic minorities studying in a different state, it shall be the duty of that state to provide them education in their primary, till their primary stage, in their mother tongue. For example, the example that I frequently quote, Marathi linguistic minorities in Tamil Nadu. It shall be the duty of the state of Tamil Nadu to give primary education in their mother tongue to these Marathi linguistic minorities. What if these minorities claim that we are not provided education in our own mother tongue? Directive under Article 365 can be issued by the center to the state, forcing that state, you have to abide by this directive. Give instruction, give education in primary stage in their own mother tongue. And if the Tamil Nadu government fails to discharge this, abide by this directive, dismiss that state government. This is the fit case of president's rule. There are schemes conceptualized by central government for various scheduled tribes, and these schemes are not implemented by the states. The states are unable to implement these schemes, or they are refusing to accept these schemes. Directive can be issued by the center to that state, accept that scheme, which is for the welfare of the scheduled tribes. If the state fails to abide by this directive, dismiss that state government. This is the fit case of president's rule. But if there is an allegation of corruption against a minister, you can't impose president's rule. If there is breakdown of law and order, you can't impose president's rule. If Lok Sabha election results are different from state elections, that's what Janata Party did 1977. Since we have won the Lok Sabha election, why are these opposition ruled states continuing? Governments continuing in states ruled by the opposition. They have lost the Lok Sabha election. Lok Sabha election and the state legislative assembly election are separate. You can't form the results of the Lok Sabha election as the basis to dismiss the government in a state which has won the state election. That cannot happen. Similarly, failure of a political party to live up to its election promises, that cannot be construed to be breakdown of constitutional machinery. This is an unfit case of president's rule. But then when all this was being spoken about, the Attorney General was smiling. The Supreme Court asked, the SR Bommai case, Supreme Court asked the Attorney General, what are you smiling? Why are you smiling for? Attorney General said, sir, you are talking about judicial review. Listen to me carefully. It's a very interesting, very important point. Supreme Court, you're talking about judicial review. Said, yes. What is that judicial review? That means if president's rule is imposed, the judiciary will have the power to review it and see whether it was the fit case of president's rule or unfit case of president's rule. Attorney General said, this is where you're wrong, Honorable Supreme Court. Said, why? Look at the process. Report is sent by the governor or even otherwise, sent to the president. President refers this matter to the cabinet. Cabinet now advises the president. Cabinet now advises the president whether president's rule is to be imposed or not. My lord, have you heard of Article 74, Clause 2? Sir, what is 74, Clause 2? The advice of Prime Minister and his Council of Ministers to the President cannot be inquired into in any court of law. My lord, you have listed down proper cases, improper cases of President's rule, fit cases and unfit cases of President's rule. And you are issuing this order on the premise that you would know what advice was given by Council of Ministers to the President, whether that is fit case for President's rule or unfit case of President's rule. But my lord, for God's sake, tell me, how can you violate Article 74, Clause 2, which says any advice given by Prime Minister and his Council of Ministers to the President cannot be inquired into any court of law. You cannot go through that advice. The Supreme Court said you have raised a valid question, 100%. We will not go into that advice, yet we will conduct judicial review. Sir, how will you conduct judicial review without going into the advice? Show the documents on the basis of which you made that advice. You have to satisfy that material documents exist on the basis of which the advice was given. Sir, what are you saying? The advice by Prime Minister and his Council of Ministers shall not be inquired into any court of law. That we know. We will not go into that advice. But you have made this advice on the basis of what document? Show us that document. Possibly show us the governor's report. Possibly show us the IB report. Show us the raw report. Show us any report on the basis of which the Prime Minister has given this advice to the President that you have to impose President's rule in that state. And it is for us to be satisfied whether that report can lead to you making an advice to the President that impose President's rule. And that is exactly what happened in Arunachal Pradesh. Arunachal Pradesh, the Congress government was dismissed by the President of India. President's rule was imposed. The government approached the Supreme Court, asked the Supreme Court on what basis is the President's rule imposed, because you have the power of judicial review. The Supreme Court said, on what grounds did you impose President's rule? We cannot go into the advice, exactly what advice you have given to the President, but on the basis of what document did you make that advice? Governor's report? What is mentioned in the governor's report? So there are many things mentioned in the governor's report. One thing which was mentioned is that Mithun was slaughtered. Mithun is an animal like a buffalo in Arunachal Pradesh, which is, I think, the state animal of Arunachal Pradesh as well. Mithun was slaughtered outside the Legislative Assembly. This was viewed by the governor that there is breakdown of constitutional machinery. Advised the President, please dismiss the state government. Supreme Court said, what rubbish. Just because a Mithun was slaughtered outside the Legislative Assembly and you are saying this is the breakdown of constitutional machinery? On this ground, you advise the President, dismiss the state government, impose President's rule. This is unconstitutional. The Chief Minister, you are restored. The old Congress Chief Minister, you are restored. Because the Supreme Court has prevented the misuse, the abuse of Article 356 because of this beautiful judgment, which said secularism is part of the basic structure, which said federalism is part of the basic structure. S.R. Bommai versus Union of India. The Attorney General said, but sir, you are again mistaken. I said, why? President's rule is imposed. Clear? Yes. What is the first casualty in President's rule? The Chief Minister, Council of Ministers are dismissed. Right, sir. What if we will dissolve the Legislative Assembly as well? Then what will you do? We have dissolved Legislative Assembly. After that, you will conduct judicial review. What will be the logic of that judicial review? It's like a post-mortem exercise which cannot revive the dead. The Supreme Court said you're wrong. When we do judicial review, we have the power to revive back the dissolved Legislative Assembly. So if a Legislative Assembly is dissolved illegally, where there was no justification for the imposition of the President's rule, even after some time, we can revive back that dissolved Legislative Assembly. That's our power under judicial review. And we are telling you, do not dissolve Legislative Assembly unless and until both Lok Sabha as well as Rajya Sabha approve the continuance of President's rule by simple majority. Unless and until both houses of the Parliament pass a resolution approving President's rule, do not dissolve Legislative Assembly. And even if you do that, we have the power to revive back that dissolved Legislative Assembly. That is President's rule. Any questions? Let me know. But sir, you are saying suspension of legislature took place during President's rule. Then how both houses pass a resolution? Lakshmi, Legislative Assembly of that state, which is under President's rule, is suspended. Approval is to be given by both houses of Indian Parliament, which means Lok Sabha and Rajya Sabha. When revoked, will new election be held in that state? If the President's rule is revoked, which means the same Legislative Assembly continues. Now, if that Legislative Assembly is able to elect a leader who will become the Chief Minister, if there is a political party which is in a position to form the government, the same Legislative Assembly will continue. If no government is possible, then it's a fit case of President's rule. Dissolve the Legislative Assembly and have fresh elections. Sir, in West Bengal, government is not implementing CSS schemes such as Ayushman Bharat. Is this a valid ground? No, this is not a valid ground for the imposition of President's rule because it does not deal with a scheme specific for tribals. Article 365. Under Article 365, directives are issued by the center to the states, and these directives are binding on the states. If you fail to abide by this directive, then under Article 356, President's rule can be imposed. Is President's rule applied on newly created state? What does that mean, newly created state? In any state, whether new or old, young or old, healthy, unhealthy, big, small, whatever, if there are fit conditions for the breakdown of constitutional machinery, President's rule can be imposed. There is no distinction between new and old. Sir, if state legislative assembly election is done through first past the post system, then what is the issue of majority? As in, what is the issue of majority? In a sense, you are saying Lok Sabha will give the approval, but in Rajya Sabha, government may not be in the majority. So then Rajya Sabha, the Rajya Sabha may not approve President's rule, which means you can't continue with President's rule. Same government will be restored to power. Yes, if incorrectly a state government was dismissed under Article 356 And if the courts find out that this was not a fit case of president's rule, as happened in Arunachal Pradesh in 2016, then the same government will be restored. Is fit, unfit conditions applicable? Yes, because that is the order of the Supreme Court. And any order of the Supreme Court is binding. But during farmers' protest, they blocked railway, but no action was taken. Why? If the central government would have wanted, they could have sent a notice under Article 365, sent a directive under Article 365. And if that directive was violated, then president's rule could have been imposed. So the government, look at the beauty of the central government during the farmers' protests. Whether you criticize them or what, they displayed a lot of maturity in dealing with the farm protests. Otherwise, the government does not engage with the protesters, no matter who the protester is. But there were multiple rounds of talks with the farmers on these bills. In fact, there are strong arguments that these three farm laws were for the benefit of the farming community. But if the farmers at the end of the day did not want this, the government succumbed to the pressure and revoked the farm bills, repealed the farm laws. But if the central government was adamant, it could have sent a notice to a state that you have to unblock these railways. And if then they failed to abide by this directive, then president's rule could have been imposed. So I have the power to remove you from the class. I'm not exercising that power. As simple as that. The central government does have the power to issue the directive, but it did not exercise that power. These are different things. Now, there's a student asking, what is Bamai case? I was discussing the entire Ramayana. And now the same simple question. No, sir. In what is the issue of making government by majority if election is done through first past the post system? My dear, if there are 100 MLAs who have been elected on first past the post system, but these 100 MLAs belong to different political parties. Now, which political party will be able to form the government? That party which has the majority of these MLAs, which has the simple majority in the Legislative Assembly. For that, we need the majority in the Legislative Assembly. Okay. We will discuss financial emergency. It's a very short topic. After that, we will take a break. And once we return from the break, we will discuss various schedules. Bear with me for some time. We'll discuss financial emergency. What is financial emergency under Article 360? If the president is satisfied. But this is not the personal satisfaction of the president, satisfaction of the cabinet. If the president is satisfied, but what will satisfy the president? If the financial credit or the financial stability of the government of India is under threat, what the president can do, president can proclaim financial emergency. National emergency is proclaimed because of war, external aggression, armed rebellion. President's rule, which is known as state emergency, is imposed on the grounds of breakdown of constitutional machinery. What if our financial system collapses? For example, we have no forex reserves. For example, we have no money to pay our employees. For example, we have no money to get imports of crude oil and other essential commodities. That means our financial stability is under threat. In that case, what the president can do, president can proclaim financial emergency. But once this financial emergency is proclaimed, proclamation of financial emergency, it is done by the president, proclaimed by the president on the advice of cabinet. Clear? Once it is proclaimed, within 2 months, just like President's rule, within 2 months, both Lok Sabha as well as Rajya Sabha, they will have to approve what? Financial emergency. How? By passing a resolution. This resolution should be passed by simple majority. And once it is approved, it continues unless and until revoked by the president. If the president is satisfied under Article 360 of the Constitution that the financial stability and credit of India or any part of the territory of India is under threat, then what president can do? On the advice of the cabinet, proclaim financial emergency. Once the financial emergency is proclaimed, then parliament has to approve. Just like president's rule, within 2 months, both Lok Sabha as well as Rajya Sabha, it has to approve this financial emergency by simple majority. And if it is approved, it continues forever and ever and ever, unless and until it is revoked by the president. Which means national emergency, once it is approved, continues for 6 months. Then give parliamentary approval, get parliamentary approval, continues for 6 more months. Then get parliamentary approval, continues for 6 more months. That means every 6 months you have to go to the parliament and seek their approval. For president's rule, once it is approved, it continues for 6 months, then another 6 months. That means for a year. Can it continue beyond 1 year? For 2 more years, but 6 months at a time. But there is no upper limit when it comes to financial emergency. And there is no periodic parliamentary control. When we say there is no periodic parliamentary control, it means once it is approved by both houses of the parliament by simple majority within 2 months of its proclamation, the national emergency continues unless and until it is revoked by the president on the advice of the cabinet. Clear? But if one house approves financial emergency, other house does not, then financial emergency cannot continue beyond 2 months. But if it is approved by both houses of the parliament within 2 months of its proclamation by simple majority, it continues unless revoked by the President of India. But what happens during financial emergency? Financial emergency, touch wood, luckily, has never been imposed in India. Never imposed in India. Neither in 1991, when there was financial crisis in India. And that crisis is known as the BOP crisis, balance of payment crisis, which you will study in economics. When because of the Iraq-Kuwait war, these are oil-producing nations, the prices of crude oil skyrocketed, and ultimately it drained our forex reserves. And according to various reports, we had forex reserves, foreign exchange, which could have lasted only for a week. Some said no, the foreign exchange could have lasted only for 3 days. But be that as it may, it is then that we started selling our gold. The government of India, which had the gold reserves, started selling the gold reserves. And ultimately, IMF came to our rescue, International Monetary Fund. And it is because of that BOP crisis that ultimately India started with liberalization. When the most famous of all the budget were passed, when Dr. Manmohan Singh was the finance minister in 1991, Mr. Narasimha Rao was the prime minister in 1991, when our economy opened up, liberalized, when we started giving access to the foreign companies to enter India. So that is why some people say we would not have carried out liberalization unless and until it was forced on us by IMF. Just like what IMF is doing today with Pakistan, or what IMF did with Sri Lanka because of their severe economic crisis. But despite that severe economic crisis, BOP crisis in 1991, financial emergency was not imposed in India. There was another big crisis in 2008. Again, the crisis which you will study and discuss in economics, where there was a big crisis because there were some insurance companies which collapsed in United States. AIG, Fannie Mae, Freddie Mac, Lehman Brothers, all these institutions, they collapsed during the economic turmoil of 2008. But there were perhaps two countries only which survived, which were not adversely affected by this 2008 global financial crisis. One was China, the other was India. And that is what gave Manmohan Singh another term in 2009, because he handled that global financial situation quite effectively. But what exactly happens during financial emergency, if at all financial emergency is imposed? The government may seek and ask for austerity. What is austerity? Austerity in the sense, family, rich family, business family, but ultimately now the business collapsed. So all their lifestyle will have to change. They will have to start with austerity measures. That means they'll have to cut down their costs. So in financial emergency, austerity can become a norm. Norm in the sense, the government ministers will be asked, don't travel by business class, travel economy class. Don't stay at the five-star hotels. Stay in the government accommodations where you won't even get the tap water. But whatever it is, austerity. And something which was prescribed after and during this 2008 global crisis, when the then finance minister, Mr. Uh, Pranab Mukherjee, he asked all the ministers that stop staying at the five-star hotels, either take up your own accommodation or use the government accommodation. So the then External Affairs Minister S.M. Krishna used to stay at a five-star hotel in Delhi. Same goes with Dr. Shashi Tharoor as well. He was asked, why do you stay at five-star hotel? He said, my bungalow is getting renovated. Till the time it gets renovated, I have to stay here. And they were traveling business class. And now when these austerity measures were released, he gave the speech, he wrote this tweet, which led to him getting sacked from the ministry. Basically, he resigned as the minister. Why? Because he said, he was asked, tell us, minister, next time you travel to Kerala, will it be cattle class? Cattle class was a derogatory term for economy class. And Dr. Shashi Tharoor replied, yes, absolutely, in cattle class, out of solidarity with our holy cows. Gai Mata, how can you criticize it and use objectionable words? BJP raised protest, and ultimately Shashi Tharoor was told, please resign. And he resigned. But be that as it may, what are we talking about? We are talking about financial emergency. If the president is satisfied, on the advice of the cabinet, when there is a threat to the financial stability and credit of India, the president may proclaim national emergency. It has never been imposed. But if at all it is imposed, what may happen? What may happen is austerity. Although financial emergency was not imposed, even then austerity measures were started in 2008, where basically you were asked to cut down on the useless costs. Similarly, what can happen, a provision can be that all the salaries of important constitutional functionaries, government employees can also be reduced. Because during financial emergency, the executive authority of the union shall extend giving directions to any state to observe canons of financial propriety. What does that mean? Austerity. That means only the central government practicing austerity? No. The central government will ask the states as well. Your ministers will also not travel business class. Your ministers will also not stay in five-star hotels. You also have to observe canons of financial propriety, which means austerity. All your government employees reduce their salary. We are also reducing our salary of the government employees. All the government employees, we will reduce the salary. That can happen during financial emergency. All your bills, money bills, all your budget should be reserved for the consideration of the president. That means when it comes to the financial system, our country becomes unitary during financial emergency. That means center tells the state, reduce the salary of your employees. Center tells the state, your bills, your money bills, your financial bills, your budget should be reserved for the consideration of the president. Maybe during financial emergency, in fact, the distribution of revenue can also be stopped, because there is something called Consolidated Fund of India. And whatever money is there in Consolidated Fund of India, it is to be shared with the states. When it is to be shared with the states during national emergency, even that sharing may stop. May stop. In fact, all the salaries of the employees, including the judges of the high courts and Supreme Court, their salary can also be reduced. That can happen during financial emergency. But luckily, financial emergency has never been imposed in India, neither in 1991 because of the BOP crisis, nor in 2008 because of the global financial crisis, nor in 2020-21 because of the crisis created by the COVID-19 pandemic. And luckily, hopefully, it will never be imposed. But what can happen during financial emergency? Center and states, their financial relations will become unitary. Center will have all the powers when it comes to finances. Revenue distribution can stop. The center can ask states plan austerity measures, observe canons of financial propriety, don't travel in the business class, don't stay at the five-star hotels, limit your expenses, start eating regular food instead of using high protein diet, whatever it is. Reduce the salaries of their employees, including the judges of the high court. Everything can happen in financial system when financial emergency is imposed. Questions, please. Sir, please tell private accommodation of minister is given by government. Yes. Any questions? Sir, is there any chance to impose financial emergency in Pakistan? That means we will impose financial emergency there. Why would we do that? Or they will impose financial emergency on themselves. They are already in a state of financial emergency, whether they say it or not. Austerity means cost cutting. Instead of spending 1 lakh rupees, spend 10,000 rupees. Okay, no questions now. Then let's meet 8:05 and we will discuss the schedules of the Constitution. See you on the other side of the break. Shall we start? If they travel by plane, then that money is given by the government? Absolutely yes, because they are traveling on official purposes. Now let's look at the schedules of the Constitution. We will discuss schedules 1 to 10. Schedule 11 deals with Panchayati Raj institutions. Schedule 12 deals with municipalities. And these two schedules we will discuss on Monday when we will talk about local governments. Local governments in rural areas, Panchayati Raj institutions. Local government in urban areas, known as urban local bodies, the municipalities. Schedule 1 we have discussed. Let's recap it. Schedule 1 deals with the names of the states and union territories. So, Schedule 1 will talk about 28 states and 8 union territories. What is a schedule? Schedule is an explanatory memorandum of an article. If an article requires more explanation, add that explanation at the end of the Constitution in the form of a schedule. Why? Because this is to ensure that an article which has more explanation, that article does not become bulky. So if an article requires more explanation, add that explanation at the end of the Constitution in the form of a schedule. Initially, there were 8 schedules. Now we have 12. And you may also be asked to match the following when these 4 schedules were added to the Constitution. Ninth schedule was added by the first Constitutional Amendment Act 1951. 10th schedule was added by 52nd Constitutional Amendment Act 1985, which is also known as Anti-Defection Law. 11th schedule and 12th schedule. 11th was added by 73rd Amendment. 12th was added by 74th Constitutional Amendment Act 1992. And 11th schedule, as I said, deals with Panchayati Raj institutions. 12th deals with municipalities. So these 4 were added to the Constitution later. Originally, there were 8 schedules. Now there are 12. First schedule deals with the names of the states and union territories, which means all the details of 28 states, their territory, and 8 union territories and their territory will be mentioned in Schedule 1. Schedule 2 talks about salaries. Salaries of important constitutional functionaries. For example, what is the salary of president and the governor? Mentioned in the second schedule. What is the salary of the speaker, deputy speaker, chairperson, and deputy chairperson, whether of Lok Sabha or Rajya Sabha, whether of Legislative Assembly or Legislative Council? Where is it mentioned? Schedule 2 of the Constitution. It also talks about the salaries of the judges of the Supreme Court and High Court, talks about the salaries of the CAG. All these important salaries are mentioned under second schedule of the Constitution. Schedule 3 talks about oath and affirmation. And we have discussed previously what is the difference between oath and affirmation. Oath is for a believer. I swear in the name of God. Affirmation is for non-believer. I solemnly affirm that I will abide by the Constitution, respect its ideals, so on and so forth. The difference is that the minister, whether the minister at the central level or the minister at the state level, they take 2 different types of oaths. One is oath of office and the other is oath of secrecy. What is this oath of office? For example, I, Sarmad Mehraj, do swear in the name of God that I will bear true faith and allegiance to the Constitution as per the law established, and that I will faithfully discharge the duties of my office. That's the oath that I take. But as minister, I am privy to some information as well. I, as a minister, if I'm the defense minister, I would know all the details regarding the Rafale jet, for example. What are the features of Rafale? How are they different from the fighter jets released by the United States? These details, I should keep it secret. I can share it with Prime Minister, I can share it with other cabinet colleagues, but I can't share it with you, I can't share it with my family members, I can't share it with others. And for that, we have oath of secrecy that I will not directly or indirectly communicate or reveal to any person the details about my office. What is the work? What are the functions that I do? And how the decisions are taken. So, this oath of office as well as oath of secrecy is mentioned in Schedule 3 of the Constitution. So, in match the following types questions, this can be important. For example, here is the schedule, and here is the purpose. Schedule 1 deals with names of the states and union territories. Schedule 2 deals with what? And you'll have to match the following. Schedule 2 deals with the salaries. Schedule 3 deals with oath and affirmation. Schedule 4, Schedule 3 also talks about oath for others. For example, if you are a candidate contesting election, when you're filling your nomination papers and you're submitting these nomination papers to the returning officer, who is the district collector, for example. If it's a Lok Sabha election, the returning officer is the district collector. If it's a legislative assembly election, the returning officer is the sub district collector. I have to subscribe to an oath as a candidate contesting the election. That oath is also mentioned in Schedule 3 of the Constitution. Judges of the Supreme Court, they take an oath. The Comptroller and Auditor General, before he assumes office, he also takes an oath. And that oath also is mentioned in Schedule 3 of the Constitution. Clear? Schedule 4 talks about representation of states in Rajya Sabha. How many MPs from Uttar Pradesh will be there in Rajya Sabha? 31. Where is it mentioned? Schedule 4 of the Constitution. How many MPs from Maharashtra will be in Rajya Sabha? 19. Mentioned in Schedule 4. Tamil Nadu, 18. Mentioned in Schedule 4. Andhra Pradesh, 11. Mentioned in Schedule 4. Telangana, 7. Mentioned in Schedule 4 of the Constitution. Clear? Then Schedule 5 and Schedule 6. Both these schedules talk about the administration of tribal areas. Which are these tribal areas? For that, we need to understand who are these tribes. We have discussed previously, but again, let's discuss it again. Tribes are basically aboriginals. We say these are the original residents or original people of India, natives. According to various theories, now these theories have also been discredited, but whether right or wrong, we don't know. The point is that some theories say Aryans came from abroad. They were not the original inhabitants of India. Aryans came from, for example, Central Asia, and then they entered India. And when they entered India, the original inhabitants of India, they were pushed towards the forests. And these individuals are known as tribes. Now, these tribes, they have maintained their own distinct culture. They speak their own language, which is different from the mainland India. They have their own cultures, which is different from the mainland India. They have their own practices, which is different from the people of the mainland India. So they have maintained their distinctiveness. And it is during colonial period that there was series of tribal uprisings or revolts. Series of tribal uprisings and revolts that revolted against the British. And you will discuss about these tribal revolts in modern history when you will discuss modern India. Majority of these tribal revolts or these agitations, they were principally on land. Land in the sense, tribal culture, it was assumed that it is an egalitarian culture where there is no set of private property, where all the tribals, they occupy a particular land, and whatever they sow on this land, they equally distribute it amongst the tribals. And these tribals, what they also do, since they're away from mainland India, there was no concept of money. So it was basically some sort of a barter system. Barter system in the sense, if you have rice, for example, paddy, for example, you will exchange it for wheat. If you have wheat, you will exchange it for milk. So there was no concept of money. But then when the colonial period started, when British entered India, they pushed money lenders to these tribal areas. They started giving and handing out loans and money to these tribals. And when these tribals were unable to repay those loans, then their land was snatched and they started revolting. They also started revolting because now restrictions were imposed by the British. What were these restrictions? For example, these tribals would indulge in shifting agriculture. For example, June, Poda, which you will discuss in geography when geography will be taught. Basically, if this is a piece of land on which I sow my crop, now after 3 years, for example, the fertility of the soil would decrease. When the fertility of the soil will decrease, I will shift and move to a different patch of land and will start sowing my crop on this piece of land because the entire land belongs to us. We are the tribals. Then British started imposing restrictions on this shifting agriculture, and that is how the tribals revolted. So one thing was that tribals are very concerned about their land. They are concerned about their agricultural practices. They are concerned about their tribal identity. They are concerned about their tribal culture. They are concerned about their tribal language. They are concerned about their customs. They have different customs altogether. For example, you split the leaf in the middle. This is how divorce takes place in some tribals. Marriage by capture, marriage by intrusion, so many different customs that are prevalent in the different tribal societies. Now the question arose after independence. When Indian Independence Act was passed in 1947, which led to the emergence of India as an independent country, we also had a constituent assembly which was responsible for drafting the constitution. Now this constitution is to be made for the entire country, which includes the tribals. Now, the question before and the challenge before the policy makers was, how do we deal with these tribals? Should we assimilate them? Assimilate them in the sense there should be no distinction between tribal and non-tribal. Non-tribals can go and enter the tribal areas and reside there. Non-tribals can go and occupy land and buy land and property in the tribal areas. All their customs should be discarded. We will have a common law for the entire country. What sort of protection should be given to these tribals? On that, Pandit Nehru and his advisor, Verrier Alvin, they followed a policy of non-interference. Non-interference in the sense, their principal purpose was, don't make these tribals second-rate copy of yourselves. Don't make these tribals second-rate copy of yourselves. Which means allow them to develop on the lines of their own genius. Don't force them. Don't tell them that you have to adopt this level of education. You'll have to follow these business practices. You have to follow these trades and occupations. Don't tell them. Let them decide what is good for them. Basically, don't force their integration. Keep them separate. Although part of India, but keep them separate. Give them protection. Give them protection over land. Give them protection over their customs. And for that, constitutional protections were made in the form of Schedule 5, in the form of Schedule 6 of the Constitution. Schedule 5 talks about the administration of these tribal areas. But in which states? States other than Assam, Meghalaya, Mizoram, and Tripura. That means in all other states, except these 4 states, they will come under Schedule 5 of the Constitution. And the tribals in these 4 states, Assam, Meghalaya, Mizoram, and Tripura, they will come under Schedule 6 of the Constitution. So even tribals were looked at differently. Not all tribals are the same. Some require more protection, some require less. Some require one form of protection, some require other forms of protection. That is why Constitution says we will give them protection. Protection in the form of Schedule 5 of the Constitution, Schedule 6 of the Constitution. Schedule 5 talks about the administration of tribal areas in states other than Assam, Meghalaya, Mizoram, and Tripura. Why these four states are left separately, we will discuss slightly later. But Schedule 5 talks about the administration of the tribal areas in states other than Assam, Meghalaya, Mizoram, and Tripura. These four states are dealt exclusively by Schedule 6 of the Constitution. What's the difference between the two schedules? Let's discuss. Why some states are excluded and some states are kept under Schedule 6? Let's discuss. Schedule 5, for example, it gives responsibility to the governor. That governor will have to submit a report. This report can be annual or at any time asked by the president. What will be mentioned in this report? How these tribal areas are administered. President will ask the governor, every year you will have to give us the annual report. Or whenever I will ask, maybe I will ask after a month, maybe I'll ask after 6 months, you will have to give me that report. And you will have to tell me in that report how you are administering this tribal area. The constitutional protections that we have given to these tribals, whether you are adhering to them or not. Give us this annual report. But Schedule 5 says, President has the power to establish a tribal area, to establish a tribal area, that's the power of the president. To administer a tribal area, that's the power of the governor. Establish a tribal area, abolish a tribal area, alter a tribal area. If the president feels, on the advice of the cabinet, naturally, that in a particular state, there is a significant number of tribal population. But the state is not in, this is not in Assam, this is not Meghalaya, this is not Mizoram, this is not Tripura. In states other than these four, wherever there is a tribal population, the president can establish a tribal area. And there are 11 states in India where we have these tribal areas. Tamil Nadu, Andhra Pradesh, Telangana, Chhattisgarh, Odisha, Madhya Pradesh. These are various states where we have the tribal areas. If the president establishes a tribal area, then it is the responsibility of the governor to administer this tribal area. And how does the governor administer this tribal area? Based on Tribes Advisory Council. Who are these tribes advisory? Who all are part of this Tribes Advisory Council? 3/4 members are tribal MLAs, remaining nominated by governor. What does that mean? This is a state other than Assam, Meghalaya, Mizoram, and Tripura, because these four states are dealt separately by Schedule 6 of the Constitution. We are talking about Schedule 5. If the president feels that there is a significant tribal population in that state, any part of that state, for example, Telangana, for example, Chhattisgarh, for example, Madhya Pradesh, the president can establish a tribal area. And this tribal area is known as Scheduled Tribal Area. Why Scheduled Tribal Area? Because this is mentioned in a schedule. Which schedule? Schedule 5 of the Constitution. Now, once this tribal area has been established, who has the responsibility to administer this tribal area? The governor. That means Chief Minister and Council of Ministers. They have limited role when it comes to the administration of these tribal areas. That is the protection given to them. Which means the governor administers this tribal area, but how? on the basis of the advice given by Tribes Advisory Council. Who all are the members of this Tribes Advisory Council? For example, this state, Chhattisgarh, it has some tribal MLAs as well, because some seats in the Chhattisgarh Legislative Assembly are reserved for the tribals. This Tribes Advisory Council, 3/4 of their members will be these tribal MLAs. Remaining will be nominated by the governor. And whatever advice is given by this Tribes Advisory Council, that is sent to the governor. Governor may or may not accept this advice, but governor will administer this tribal area on the basis of the advice given by Tribes Advisory Council. The name itself says Tribes Advisory Council. That means it is there only to give an advice. This advice is not binding on the governor, but governor will normally act on that advice. And this protection is primarily given on land, money lending, sale of land to non-tribals. Now listen to me carefully. What is the role of this Tribes Advisory Council? There is a law passed by the parliament, or there is a law passed by the state legislative assembly of that state, which deals with land, which deals with transfer of land to non-tribals, which deals with money lending in that area. Whether that parliamentary law, whether that state law will apply to this tribal area or not, that will be advised by this Tribes Advisory Council to the governor. Which means any law which is passed by the state legislative assembly, it will apply throughout that state. But the Tribes Advisory Council will decide whether this law which deals with land, whether this law which deals with sale of land to non-tribals, whether this law which deals with money lending, whether this law will apply to this tribal area or not. Because constitution makers thought that when we look at these tribals from states other than Assam, Meghalaya, Mizoram and Tripura, they require only economic protection. We have to protect their economic interests, which means whether their land can be sold to non-tribals, they should decide. Whether the law passed by the state legislature on land, whether it will apply to this tribal area or not, that they will decide. Whether money lenders can be allowed to come or not, that they will decide. That means for economic matters, they should be given protection, and that is the purpose of Schedule 5 of the Constitution. Long story short, there are tribals, but tribals can be segregated into two broad categories. Tribals in states such as Assam, Meghalaya, Mizoram and Tripura, they are dealt by Schedule 6 because they require more protection. And what sort of protection, I'll tell you. But tribals who are part of the Schedule 5, that means part of those states other than Assam, Meghalaya, Mizoram and Tripura. These tribals in Schedule 5 areas, they require only economic protection. Why only economic protection? Because these tribals, for example in Jharkhand, these tribals, they are more or less similar to the non-tribal population of Jharkhand. That means in terms of language, in terms of religion, in terms of customs, there is not much difference between a tribal and a non-tribal in Jharkhand, tribal and a non-tribal in Chhattisgarh, tribal and a non-tribal in Madhya Pradesh. But still they should be protected. Protected in their economic sphere. Whether their land can be given to non-tribals, whether non-tribals can reside in these lands, whether money lenders should be allowed or not, that will be decided by the Tribes Advisory Council. And this Tribes Advisory Council will consist of 3/4 of the members will be the tribal MLAs. That means tribal MLAs and some nominated by the governor. Together they will decide how we will protect the economic interest of those tribals who are part of Schedule 5 of the Constitution. But constitution makers realized that when we look at states such as Assam, Meghalaya, Mizoram and Tripura, there is a vast difference between a tribal and a non-tribal. So we should not only protect their economic interests, we should protect their social customs as well. We should protect their religious customs as well. We should protect their family customs as well. We should protect their language as well. We should protect their system of justice as well. but not the entire North, not the entire Assam or Meghalaya or Mizoram or Tripura is a tribal state. There are only 3 districts in Assam which are tribal areas. Similarly, 3 districts in Meghalaya. Similarly, 1 district in Tripura. 3 districts in Mizoram. For example, in Meghalaya, where we have the elections, there are 3 dominant tribes, 3 distinct tribes: Garo, Khasi, Jaintia. These are 3 hills also in Meghalaya: Garos, Khasis, Jaintias. On the name of these 3 hills, there are these tribes: Garos, Khasis, Jaintias. Clear? That means not the entire Meghalaya, but these 3 districts of Meghalaya, they are the tribal area. And to protect these, we have Schedule 6 of the Constitution. What does that mean? Listen to me carefully. For example, this is Meghalaya. Clear? There are 3 distinct tribes: Garos, Khasi, Jaintia. Clear? The district where Garos are residing, this district will be converted into an autonomous district. And now you will realize why Ladakh, for example, is today protesting. Ladakhis are protesting. They're saying either we were happy with Jammu and Kashmir as part of that state, or we need protection under Schedule 6 of the Constitution. Why is it that they want protection under 6th schedule? What is that they can get if they are included in Schedule 6 of the Constitution? For that, Garos, wherever they are residing, the entire district where Garos are residing will be converted into an autonomous district. Autonomous district in the sense, all the members of this district will be directly elected by this tribe. For example, if this autonomous district has 30 members, 26 will be directly elected by the Garos, 4 will be nominated by the governor. And this autonomous district will be given an autonomous district council. And this autonomous district council will have executive powers, will have legislative powers, will have judicial powers, will have financial powers as well. What does that mean? This is Meghalaya, which comes under Schedule 6 of the Constitution. There we have 3 districts which are under Schedule 6 of the Constitution. One is Garos, for example. Now, this district where Garos are residing is converted into an autonomous district. That means they have autonomy. Autonomy in the sense, they will elect 26 members to this district council. 4 members will be nominated by the governor. Now, this district council will pass laws which will be implemented in that Garo district. They can impose taxes as well. They can impose toll as well. These laws they can pass on their customs, on their beliefs, on their family structure. Whether a man can have multiple wives or a woman can have multiple husbands, that you decide, part of your culture. What sort of taxes can be imposed, that you decide. What sort of school system you want to have, that you decide. And if somebody is violating a law in Garo district, you will punish that based on your tribal culture. That is the autonomy provided to them. Now imagine a situation at Lok Sabha, we have people elected. In Legislative Assembly also, we have people elected. That is it for the entire country. But for Schedule 6 areas, they will have their own autonomous district council. And that district council will also be elected by the people. And then this district council will have executive powers, legislative powers, financial powers, judicial powers. And that is why we see whenever a law is passed by the parliament, it says this law will apply except on the Schedule 6 areas. Because in Schedule 6 areas, what law will be applicable that this district council passes? So it is like an autonomous state within a state. So if Ladakh is given a status of under Schedule 6 of the Constitution, now in Ladakh we can have two different tribes. One tribe will have their own district council. They will govern it on their own. Another tribe will have their own district council. They will govern on their own. That means they will elect their representatives. They will pass laws. They will have executive powers. They will have financial powers. And at the same time, they will have the power to decide whether a parliamentary law will apply to them or not. To make it even clear, if it is, for example, Meghalaya, Mizoram, Tripura, and it is Assam. Now there is a state law and there is a parliamentary law. Law passed by the state legislature, law passed by the Parliament of India. Governor gets to decide, and here president gets to decide. President will decide whether this parliamentary law will apply to these tribal areas or not. Governor will decide whether this state law will apply to the tribal areas or not. And in case of Assam, it is the governor who decides whether a parliamentary law or a state law will apply to the 3 tribal districts of Assam. Which means governor has a special responsibility in administering these tribal areas. And that is another reason why office of governor should continue. That is why office of governor is indispensable, because he has another role, she has another role to administer these tribal areas. And that is the protection under Schedule 6 of the Constitution, to protect the interests of the tribals. But tribals can be tribals of other states and tribals of Assam, Meghalaya, Mizoram, and Tripura. Why difference? Because when we look at the tribals of Garos, Khasis, and Jaintias, they are different from the other tribals. Garos are different from Jaintias. Jaintias are different from Khasis. But when we look at all the tribals of Jharkhand, they are more or less the same. Their custom is same. Their religion is more or less the same. They practice same beliefs. That is why Schedule 5 areas, we should protect their economic interests only. But Schedule 6 areas, not only their economic interests are to be protected, their social customs should also be protected, their culture should also be protected, their language should also be protected. That is why there are 2 different schedules, but for the same purpose, to protect the interests of scheduled tribes. And that is why we discuss fundamental rights as well. And in fundamental rights, there are exceptions. That you have the right to move throughout the territory of India. But in the interest of the scheduled tribe, your right to movement can be restricted. You have the right to reside and settle anywhere in the territory of India. But in the interest of the scheduled tribes, your fundamental rights can be restricted. Now I can anticipate a question. Sir, what about tribals, the Jaravas, the Sentinelese of Andaman and Nicobar, of Lakshadweep? Why are they not protected under Schedule 6 of the Constitution? My dear, Lakshadweep, Andaman and Nicobar is a union territory directly under the control of the center. But when it comes to Assam, Meghalaya, Mizoram, Tripura, and all other states, 11 states where we have scheduled area, these are states. Even within the state, they should be protected. That is why we have Schedule 5 and Schedule 6. Central government will protect the Jaravas. Central government will protect the Sentinelese. But here the state governments have limited role when it comes to these tribal areas. That is the protection under Schedule 5 and Schedule 6 of the Constitution. Any questions? For upliftment of tribal groups, why government should not interfere, and tribal groups are exercising some customs like child marriage and bad social evils. What is bad to you may be good for them, and what is bad for them may be good for you. Let them decide what is good for them and what is bad for them. Who are you and me to decide? We have to come out from this lens, this common lens that we use to evaluate the people. People are diverse, and that diversity should bind us. Ladakh demand for Schedule 6 is deserving for consideration. Whether it is deserving, undeserving, whether it will happen or not, that's for the government to decide. The governor will work in these tribal areas without the advice of the chief minister and his council of ministers. In Schedule 5 areas, on the advice of the Tribes Advisory Council, and Schedule 6 areas on the recommendations of the autonomous district councils, not the chief minister and council of ministers. Do scheduled tribes in some other states enjoy privileges under Schedule 5? No, only those areas where scheduled tribe areas are created. And there are 11 states where we have the scheduled tribe area. But there may be a tribal in Delhi, for example. There may be a tribal in some other state where we don't have a tribal area. They don't enjoy the protection under Schedule 5. Sir, if they perform child marriage, then can government stop this practice? Who is government? They are the government. They decide whether we want to do this or not. Okay. Now, Schedule 7 of the Constitution, we will discuss in great detail when we will discuss center-state relations tomorrow. Which reminds me that tomorrow we have a class, 7 o'clock in the morning till 10 o'clock. Please make sure that you attend that class. Tomorrow we are discussing one of the most important topics, center-state relations. Clear? And in the center-state relations, we will talk about Schedule 7. Schedule 7 basically talks about distribution of powers. Some powers given to the parliament under union list, some powers given to the states under state list, and some areas where both parliament as well as states can make a law. Those are what we call concurrent list. Then there is Schedule 8 of the Constitution, which talks about 22 languages, 22 Indian languages. Initially, there were 14. And now we have 22 Indian languages, which are mentioned under Schedule 8 of the Constitution. But when we look at this chapter languages, we can break this chapter into 4 parts. 4 parts in the sense, what is the language of the union? What is the language of the states? What is the language of the judiciary? And what are some special directives regarding languages, which are dealt by Articles 343 to Article 351 of the Constitution. When we look at the language of the union, what do we mean by the official language of a union? You're attending this class right now, and the medium of instruction is English. That means we communicate in English. That means the official language of this class is English. We have a separate batch for Hindi students as well. There no English word is uttered. That means there the official language is Hindi. Clear? Now, what is going to be the official language of the union? In the sense, if the union wants to communicate to a state, wants to send some recommendation to a state or a directive to a state, or the state wants to communicate something to the center, in what language will this communication start? Because there has to be an official language. For example, Mr. Modi will send a recommendation to Mr. Stalin in Hindi language, and he will respond in Tamil. Neither does Mr. Stalin understand Hindi, nor does Mr. Modi understand Tamil. although Mr. Modi can claim that he understands all the languages. But that's besides the point. So there has to be a language in which center and state will communicate with each other, or the states will communicate with themselves. That is what we call the official language. And according to the constitution, the official language of the union shall be Hindi, and the script that will be used is the Devanagari script. What is the national language of India? Anybody in the comment section, please? Abhijit, what's your question, please? I will respond. Hindi, 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 Hindi. Very good. Very good. Hindi. No national language. Hindi, Hindi. Sanskrit. Hindi. Okay. There is no such concept as national language. There is no such thing as national language. Hindi is not the national language of India. Hindi is the official language of India according to the constitution. So the constitution said official language of the union shall be Hindi in Devanagari script. But before Hindi, what was the official language? English. Now imagine a situation, we are having this class in English language. Suddenly the Baiju say, no, this class should be in Hindi. We can't immediately transition from English to Hindi. That means we will give you some time, maybe 1 day, 2 days, 10 days, 15 days. And after 15 days, we will transition completely to Hindi. And during this period, we will transact in English. That's what the constitution also said. Since prior to Hindi becoming the official language of the union, we were following English. So quick transition may not happen, may not be feasible, may not be desirable as well. So for 15 years after the commencement of the constitution, English will stop. Until 15 years, we will continue to use English as well as Hindi. What does that mean? The official language of the union shall be Hindi in Devanagari script. But since we were using English, we will use English for the next 15 years as well after the commencement of the constitution. That means from 1950 till 1965, we will use English as well, apart from Hindi. English and Hindi both will be used. When we reach 1965, English will disappear and Hindi alone will be the official language of the union. But the same constitution says, even after 15 years, Parliament, if it wants, it can pass a law to say that English will continue beyond a period of 15 years. And for that, Parliament has to pass a law. Constitution further said that after every 5 years and then after 10 years, there should be a committee set up and then a commission. What is this commission? We will set up a commission and this commission will have the responsibility. When we will set up this commission? After 5 years, that means in 1955. Then after 10 years, that means in 1960. What will this commission do? This commission will advise the central government that right now we are using English in these areas. We should stop using English in these areas. We should use only Hindi. And what are the steps that we should take to promote Hindi so that Hindi becomes the official language of the union, the only official language of the union after 1965. And once this commission submits its report, then we should have the committee of the parliament to examine this report. And the committee of the parliament should tell the government what you should do with this report. In 1955, this committee was set up. This commission was set up. This commission was headed by B.G. Kher. And the purpose of this commission was, you tell us, how can we progressively promote Hindi? How can we remove the dependence on English? For that, you suggest some recommendations. And once B.G. Kher Commission submitted this recommendation, a parliamentary committee was headed by G.B. Pant, Govind Ballabh Pant was headed to examine these recommendations. But then the constitution had said that after 10 years, that means in 1960, another committee should be set up. This committee was not set up. Why? Because there was chaos, confusion, protests, demonstrations, particularly in South India, and more specifically in the state of Madras, where there were agitations against Hindi imposition. Why should you impose Hindi on us? Our languages are beautiful, old classical languages. Hindi is a new language. Our language, whether it is Tamil, whether it is Telugu, whether it is Malayalam, whether it is Odia, whether it is Kannada, these are old classical languages. They are in existence much before Hindi emerged as the language. Why should Hindi be dominated on us? We will not accept this. There were series of protests, and ultimately the government succumbed to the pressure. A law was passed known as the Official Languages Act. This law was passed in 1963. And according to this law, both Hindi and English shall continue to be the official languages of the Union. And this time, there is no upper limit. No upper limit in the sense, we are talking about Schedule 8 of the Constitution, which initially had 14 Indian languages, then 8 more were added, and now we have 22 Indian languages. Clear? This chapter languages can be broken into 4 areas. What is the official language of the Union? That means if the Union wants to communicate, in which language it will communicate. Constitution said the official language of the Union shall be Hindi in Devanagari script. But for 15 years, English will continue as the official language of the Union as well. English as well as Hindi. But after 15 years, English will disappear. Only Hindi will be the official language of the Union. But same constitution provided an opportunity as well. Provided a way out as well. If Parliament wants, it can pass a law. Through this law, what it can do, it can provide for the continuance of English beyond a period of 15 years. And for that, a law was passed because there were protests in South India, particularly in Madras, which were protests against the Hindi imposition. And now, according to this Official Languages Act, the official language of India, of Union, is Hindi as well as English, and there is no upper limit because this act enables the use of English language indefinitely without any time limit. And that's how the compromise was reached. Now, the official language of the Union is Hindi as well as English. But what about the states? And this is what we call linguistic federalism. What is this linguistic federalism? Look at me carefully. Is there one language, Hindi for example, imposed on the entire country? West Bengal, you can use only Hindi, not Bengali. Tamil Nadu, you can use only Hindi, not Tamil. Karnataka, you can use only Hindi, not Kannada. No. States are given the choice. They can pick one language. They can pick more languages. They can pick any other language. Even if this language is not mentioned in the Schedule 8 of the Constitution, doesn't matter. You can pick 1, 2 more languages as the official language of your state. That means we will not impose, the Constitution will not impose, the center will not impose one language on you. And what it led to? Linguistic federalism. And that is why West Bengal, for example, some years ago, started Kurk and gave official language status to this language, Kurk language, apart from Bengali, apart from Urdu. Kurk will also be the official language of West Bengal. That means regional states, they have the right to pick their own language, one language, 2 languages, more languages, any language. Even if this language was not mentioned in the Schedule 8 of the Constitution, you can choose this language. And at the same time, Constitution has said that communication between the Union and the states is to be in official language. Because what is the official language of the Union? English as well as Hindi. So if the states have to communicate with center, center has to communicate with the states, it can communicate in Hindi and English. But what about states? States are given the options. They have to follow official language of the Union. Because if Karnataka and Tamil Nadu, they have to interact with each other, the chief minister will write in Kannada, the other chief minister will respond in Tamil. Problem solved. They won't understand. Even if they understand, they will, give a sense that we have not understood this. Oh, I thought you are saying block my car. Oh, I thought you were saying kill me. I killed you. Whatever it is. The states are given the options that if you want, you can communicate with each other in Hindi instead of English. In Hindi alone instead of English. So right now, if the states have to communicate with each other, they have to communicate in the official language of the union, which is Hindi as well as English. So Karnataka will communicate with Tamil Nadu in English. Tamil Nadu will communicate with Andhra in English. Andhra will communicate with the other state in English. But if they want, they can also only use Hindi and not English. And that is how there are some states such as UP, such as Madhya Pradesh, such as Jharkhand, such as Chhattisgarh, such as Bihar, they have come to an agreement that from now onwards, when we will interact with each other, when we will communicate with each other, we will communicate only in Hindi to promote Hindi. And that is constitutional, that is allowed because the states are free to choose only Hindi for their communication. But what is the language of judiciary? A petition was filed in the court, an habeas corpus petition was filed, and this petition was filed in the Hindi language. Supreme Court dismissed it, saying that is not our language. Our language is English. So if you want to communicate, you can file the petitions only in English because that is our language. The language of High Court is also English. But the language of subordinate court is their regional language. What is the language of Supreme Court? English. What is the language of High Court? English. What is the language of the subordinate court in Tamil Nadu? Tamil. Karnataka, Kannada. Subordinate court in UP, Hindi. Clear? That means in subordinate judiciary, you can choose your regional language, but high courts and Supreme Courts, they will have English. Now something has happened. What has happened? Kerala. Kerala High Court became the first high court to start publishing its judgments in local language. Is that unconstitutional? No. Why? Because although the proceedings will be in English, but once the judgment is given, you can give this judgment, you can translate this judgment, and there are some high courts which have used artificial intelligence to translate these judgments into their local languages. That can also happen. And that is basically on the insistence of the Supreme Court. Supreme Court wants these judgment copies to be accessible to large sections of the population. And for that, you can translate. You cannot give judgment in local language. Judgment is in English language, but you can translate that judgment into regional languages and upload it on your website. And that has happened in Kerala. And that should happen in all the states. That's a good thing to happen, to make judicial language accessible to all the population of that state. And similarly, there are some special directives. What are these special directives? Under Article 350. What is Article 350? I have a complaint. I'm in Karnataka right now. I'm in Bengaluru. And I have a complaint. The police is very corrupt. And I have to lodge a complaint. This is my grievance. This grievance can I file this grievance in Hindi in Karnataka? Or Hindi in Tamil Nadu? Or Tamil in Delhi? I can file this complaint in any language which is spoken in that state or spoken at the union. What is the language spoken at the union? English and Hindi. What is the language spoken in that state? Tamil or Kannada. That means in Karnataka, if I have to lodge my grievance, I can use either Hindi or English or Kannada. In Delhi, I cannot use Tamil. In Delhi, I can use either Hindi or English because that's the language spoken in that state and that's the official language of the union. So any language which is spoken in that state, any language which is spoken which is the official language of the union, in these languages, I can lodge my complaint, I can file my grievance. What is Article 350 capital A? It basically talks about something that we have discussed previously. Adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Marathi linguistic minority in Tamil Nadu. There is a directive to the state of Tamil Nadu that you provide education to these Marathi linguistic minorities, to their kids, till primary stage, in their own mother tongue, which is Marathi. That's the directive. And if you fail to abide by this directive, then under Article 365, directive can be issued to you. Abide by this directive. Abide by Article 350 capital A. And if Tamil Nadu fails to abide by Article 365, then under Article 356, President's rule can be imposed. And then Constitution also talks about a constitutional body known as Special Officer for Linguistic Minorities. If you have any complaint vis-a-vis your language, file this complaint with the Special Officer for Linguistic Minorities. And he has the power, she has the power to investigate all matters related to these constitutional safeguards for linguistic minorities. Because if these Marathi minorities, Marathi linguistic minorities, are not given education, instruction in their mother tongue in Tamil Nadu, they can approach the Officer for Linguistic Minorities. And now this Officer for Linguistic Minorities will investigate and take action against the state government. These are special directives under the Constitution. And one more, Article 351 imposes a duty on the center, not the state, center. That what center, what union you have to do? You have to promote the spread and development of Hindi language so that Hindi can become and serve as the medium of expression for all the elements of the composite culture. And that's something we have discussed in directive principles of state policy as well, which means if the state, if the center is promoting Hindi, that is not unconstitutional, because that is their duty under Article 351 of the Constitution to promote the spread of Hindi language. Then you might have heard of what is a classical language. How many classical languages do we have? 6. Sanskrit, then Tamil, then Telugu, then Kannada, then Malayalam, and the last one to be given a classical language status is Odia. Hindi is not a classical language. But what is the criteria to classify a language as a classical language? What is that classification? What is that requirement? We say this movie is a classic movie. Casablanca, a classic romantic movie of all time. This is a classic song. What is classic? Something which stands the test of the time, which is there for a long time. Imagine a language which is there in existence for the last 1500 to 2000 years. Very old language. It's a classical language because it has stood the test of the time. This language should be original. That means there are languages which are borrowed from other languages. But this language can be a classical language if it is original. And those who speak this language consider this language to be original. It's a classical language. That means a language of antiquity, which is in operation, which is in existence, which has been spoken for 1500 to 2000 years. That is a classical language. A language which is considered to be original, not borrowed from any other language. That is a classical language. And for this classical language, there are some protections, some benefits. What's the benefit? If I tomorrow start a new language, Sarmadi, new language, what is the best way to promote this language? I will set up a department in central universities and will invite applications. Students, if you want to learn, do an MA or BA in this language, you apply for this program. I will also appoint professors who will speak this language and teach this language. And at the same time, efforts will be made to, let's say, popularize this language, not just popularize, but also to protect this language, which means you will take this language. Why? This is a new language, which means there will be less people who will be qualified in this language, which means tomorrow when the jobs will be advertised in various universities, you will be the first one to get that job. Imagine the job of an assistant professor, associate professor, professor. That means you will opt for this language, which means the best way to promote a language, to protect a language, is to allow that language to have a separate department in central universities, which means more people will opt for that course. More people, once they opt for this course, they will become professors in that course. They will conduct research on that language. They will publish papers and theses on this language. And that is the benefit of a classical language. The moment a language becomes classical, financial assistance is given to that language, that you can set up the study of excellence, excellent study for that language. And beginning in central universities, there will be a separate department for that. When separate department, which means more students will opt for this. More students will opt for this, that means more research into that subject. And that is how this language will continue, 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 continue. And it will remain classical. That's the benefit. And that is why there are various languages today which are demanding, various linguistic groups which are demanding classical languages for their languages. But then there is something called three language formula. What is the three language formula? When we saw protests in Madras, in Tamil Nadu, particularly against the imposition of Hindi on the unwilling population of Tamil Nadu, and justifiably so. If they have a beautiful language, why should they speak in Hindi? And why should Hindi be thrust on them? They don't understand Hindi. So how can Hindi become the official language? Whether justified, unjustified, there can be two thoughts on that. There can be diversity of opinion. That's what Voltaire said. I disagree with you, but I will defend till death your right to say it. Disagree with me, but don't kill me. Right? A compromise was reached, a beautiful compromise in the form of a three language formula. So, what was the idea? The idea was that this is South India, and this is North. But on Google, it is showing Hindi, sir. What is showing Hindi on Google? Sir, you disappointed me by not discussing. Lakshmi, what did I not discuss? We are discussing previous year's question papers. Just give me 5 minutes. Let's finish this. We'll start previous year's question papers. I'm not running away. I'm here. You also stay here. We'll discuss. Clear? South India, for example, three language formula said three languages should be taught. For example, if it is Tamil Nadu, English will be one language taught to the students. The second will be Tamil. And the third should be preferably Hindi. And if it is North India, English will be taught as one language. Then Hindi will be taught in another language. Then any beautiful South Indian language will be taught as the third language to the kids. This way, what will happen? The beautiful South Indian languages will travel to North India. The beautiful Hindi language will travel to South India as well. That's how we can establish the objective that is mentioned in the preamble, fraternity, a sense of common brotherhood. That was the logic, that was the idea, that was the objective. That is why kids till the 10th standard, they should be taught three languages. One, English. Second, their local language. Third, if it is South India, then Hindi. If it is North India, then any beautiful South Indian language of your choice. Tamil Nadu says we will not implement three language formula. In Tamil Nadu, they follow only English and Tamil. Puducherry, for example, says we will not follow this. Tripura says no, we will not follow this. And in North India, Hindi is taught, English is taught. We thought that they will choose a South Indian language as the third language. Instead, they are taking up Sanskrit. Or they are taking up German, they are taking up French, they are taking up Mandarin. And now the new national education policy, although it is not explicitly asking states to follow the three language formula, but three language formula, the directive is should be followed. Should be followed in the sense that third language should be Hindi in South India, Third language should be any language, preferably a South Indian language in North India. But then there are those who say this is additional unnecessary burden on the kids. We should revert to two language formula, English and their local language, not any other language. And there are others who say English should be banned. It's a colonial language with colonial mindset. This should be discarded into the dustbins of the history. How many amongst you say English should be banned? Banned. No, 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 no ban. English should never be banned. No, 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 no. Thank God. English, if you see it as a language, then it's a problem. See English as a skill. The reason why there was a boom, the BPO boom, business process outsourcing boom in India, call center boom in India, at the expense of China or Japan or South Korea, is because we speak English better than the English, better than the citizens of England. And it is our command over this skill, which is English, which is being demanded in the market, in the job market. So treat English as a skill. And at the same time, all the important books, whether on medicines or engineering or law, are in English. We don't have sufficient expertise to get these translated better. Translated better in the sense, look at Union Public Service Commission, conducts examination, English paper, Hindi paper as well. And the questions which are in Hindi language are basically Google translation of the English. So even the UPSC is not able to translate the question effectively and giving a Google translated. And there are horrible mistakes in the Hindi side of the question paper that comes in your prelims and mains examination. And then the new research which is done, it is in English. So you are depriving Indians of a skill if you ban Hindi, if you ban English. You are depriving Indians of good access to good quality literature, which is in the form of books, research papers, if you ban English. So English should be viewed as a skill, not just a language. That is why English should not be banned. Then we'll discuss ninth schedule of the Constitution, and after that we will take up previous year's question papers. So Lakshmi, please stay. We'll discuss previous year's question papers. Or let's discuss previous year's question papers now, and we will discuss ninth schedule tomorrow, then 10th schedule tomorrow, then we will look at center-state relations. Okay. Let's take a look at the prelims-based questions first. Get up. Lakshmi, you should be topper. If not, then you will disappoint me. 2017, the Parliament of India exercises control over the functions of Council of Ministers through what? The Parliament of India exercises control over the functions of Council of Ministers. Through what? Adjournment motion, question hour, supplementary questions. 40% students are right. Parliament exercises control over the executive through adjournment motion, yes, because the normal business is suspended and we discuss a matter of urgent public importance. And if adjournment motion is then passed by simple majority, the Council of Ministers is censured. Through question hour, start questions, unstart questions, short duration questions, and then asking supplementary questions. That is how the Parliament is exercising control over the executive. That's how legislature keeps a check on the executive. So D 1, 2, 3 is the right answer. Maithili, the screen is displayed for everybody. Please check your connection. Question 16. Which of the following statements are correct? 2016, this question was asked. A bill pending in Lok Sabha lapses on its prorogation. Read this question carefully, please. A bill pending in the Lok Sabha lapses on its prorogation. A bill pending in the Rajya Sabha which has not been passed by Lok Sabha shall not lapse on the dissolution of Lok Sabha. One second to go. 48% students are right. A bill pending in Lok Sabha lapses on its prorogation. Incorrect. A bill pending in Lok Sabha lapses on its dissolution. Prorogation terminates the session of the parliament. And when the session is prorogued, nothing happens to the bills. Bills survive. That's why I told you, if we will not take up in this session, we will take up in the next session. Clear? A bill pending in the Rajya Sabha. So here is a bill which is pending in the Rajya Sabha, which has not been passed by Lok Sabha. Which has not been passed by Lok Sabha. That means this bill never went to Lok Sabha. Shall not lapse on the dissolution of Lok Sabha. That means this bill has originated in Rajya Sabha. It is pending in the Rajya Sabha. A bill which originates and is pending in the Rajya Sabha does not lapse on the dissolution of Lok Sabha. Correct? So B only 2 is the right answer. Question which was asked in 2015. Now this is a very easy question. A bill is referred to joint sitting. It should be passed by what? I'll give you 15 seconds for this. What is the answer? When a bill is referred to a joint sitting of both the houses of the parliament, it has to be passed. 86% students are right. Very good. It is to be passed by a simple majority of the members present and voting. And this is where, since the numerical majority is with the Lok Sabha, the will of the Lok Sabha prevails over this joint sitting. Question which was asked in 2014. There is no mention of no confidence motion. A confidence motion can be introduced only in Lok Sabha. Okay. Five seconds to go. 50% students are right. 40% say B. There is no mention of a no confidence motion in the Constitution of India. Correct? Does Constitution talk about no confidence motion? No. Then where is it mentioned? It's mentioned in the rules of business and procedure. Motion of no confidence can be introduced only in Lok Sabha. Yes. Why? Because this is what we call parliamentary democracy. And in parliamentary democracy, the Council of Ministers are accountable only to Lok Sabha. One way in which you can hold the Council of Ministers accountable is through no confidence motion. Both the statements are correct. C is the right answer. The question which was asked in 2013, what will happen, what will follow if a money bill is substantially amended by the Rajya Sabha? Now, you might say that UPSC is wrong, which it is, because Rajya Sabha cannot amend a money bill. Rajya Sabha can only suggest recommendations. But then the statement is correct because it talks about recommendations. But the question word is different, is difficult, is not correct. But be that as it may, okay, what is the answer to this question? I'll give you 10 seconds. Easy question. What is the answer? I can't see the poll. Can you take this poll now, please? Okay, 96% students are right. When what will follow if a money bill is substantially amended by Rajya Sabha, the Lok Sabha may still proceed with the bill, accepting or not accepting the recommendations of the Rajya Sabha. Clear? And once 14, even if Rajya Sabha does not act on this money bill, then after 14 days, it shall be deemed that money bill is passed by both houses of the parliament. 2015, consider the following statements. The Legislative Council of a state in India can be larger in size than half of the Legislative Assembly of that particular state. The governor of a state nominates the chairman of the Legislative Council of that particular state. Which of the statements are correct? 30 seconds. What is the right answer? The Legislative Council of a state in India can be larger in size than half of the Legislative Assembly or one third. It's one third. Legislative Council has a range. Minimum, we can have 40 MLCs. Maximum it can go up to is one third of the strength of the Legislative Assembly. So first is incorrect. The governor of a state nominates the chairman of the Legislative Council. We discussed yesterday that chairman of Legislative Council is elected by MLCs, that too by simple majority, which means D, neither one nor two is the right answer. This question was asked in 2014. Which of the following are discretionary powers given to the governor? Sending a report to the president for imposing president's rule, appointing the ministers, reserving certain bills for president, making rules to conduct the business of the state government. I'll give you a minute for this. Let me know what's the right answer. MLC full form is Member of Legislative Council. So state legislature can be Legislative Assembly, Legislative Council. You are a member of Legislative Assembly, you are an MLA. You are a member of the Legislative Council, you are MLC. Which of the following are the discretionary powers given to the governor of a state? Varun says, I selected incorrectly. Don't do that. You can't correct your incorrect answer even at the time of the examination. Luckily, 63% students are right. Good. Sending a report to the president for imposing president's rule, it's a discretion. Appointing the ministers, it is not a discretion. Incorrect, only on the advice of the chief minister. Reserving certain bills passed by legislature for consideration of the president. In fact, governor can reserve any bill for the consideration of the president. Making rules to conduct the business of the state, incorrect, because this is done only on the advice of the government. So 1 and 3, B is the right answer. Question number 18. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, then Assembly is dissolved, powers of legislature, Parliament, Article 19, President can make laws regarding that state. What is the right answer? Tell me. I will give you 15 seconds. People are confused between A and D. Assembly of the state is automatically dissolved. We just studied this. It's kept under suspension, suspended animation. Article 19 has no relation with president's rule whatsoever. Article 19's enforcement is suspended when national emergency is imposed. Article 356 talks about president's rule. And president's rule we have discussed. The president in his proclamation may assume all the powers of the governor and will say that the powers of the legislature will be exercised by parliament or under the control of the parliament. So B is the right answer. (2017) Which of the following are not necessarily the consequences of the proclamation of president's rule in a state? Dissolution of the state assembly, removal of the council of ministers, dissolution of the local bodies. Which of the following are not necessarily the consequences? The same question. Let me know. 15 seconds. D option also correct, sir. No, Ashish, president cannot make a law. Law for that state which is under president's rule is made by parliament or some authority under the parliament. 37% say D. Dissolution of state assembly, incorrect. It's not necessary consequence of president's rule. It may happen, but may not happen because the legislative assembly is kept under suspension. Maharashtra Legislative Assembly, president's rule was imposed, was not dissolved. It was suspended. President's rule was revoked. The legislative assembly survived. Removal of the council of ministers, correct, happens. It's a necessary consequence. Dissolution of local bodies. Have we discussed that local bodies are dismissed when president's rule is imposed? Have we discussed? If we haven't discussed, that means it's not correct. So the question is asking which of the following are not necessarily. So 1 and 3 are not necessarily. B is the right answer. 2019, the ninth schedule of the Constitution was introduced during the prime ministership of, I'll give you 10 seconds. What is the answer? I think if not 100%, at least 80% students should be correct. Because 20% I know what is the answer that they will give. My God, I am wrong. So it's 57% students are right. And 30% I thought would make it Indira Gandhi. Not everything is done by Indira Gandhi. In fact, I mentioned the year as well. When schedule was added. Ninth schedule was added when? 1951. Was Indira Gandhi the prime minister then? No. Apply logic. Jawaharlal Nehru. Clear? 2015, the provisions of fifth and sixth schedule are made in order to. Now, this is where all of you should be right. 15 seconds. What is the right answer? How Council of Ministers may be removed. Council of Ministers shall be removed. The first casualty, the immediate casualty is Council of Ministers are gone, dismissed. That's what happens in the President's rule. 92% Janta is right. To protect the interest of the scheduled tribes. Mains-based questions. And we have discussed these questions. Now, this is how the questions have been framed. The powers, privileges, and immunities of Parliament and its members, as envisaged in Article 105 of the Constitution, leave room for a large number of uncodified and unenumerated privileges to continue. Assess the reasons for the absence of legal codification of the parliamentary privileges. How can this problem be addressed? Now, look also at the year when this question was asked, 2014. What happened in 2014? Andhra Pradesh was bifurcated. And when Andhra Pradesh was bifurcated, when that bill was to be debated in the parliament, one MP started spraying pepper on the other members, pepper spray MP. That is when there was a lot of debate on the parliamentary privileges that are available. So current affairs. Current affairs is everything for mains examination. Indian Constitution has provisions for holding joint session of the two houses of the parliament. Enumerate the occasions when this would normally happen and also the occasions when it cannot, with the reasons thereof. The joint session of the parliament can be notified by the president on the advice of the government when on a particular bill there is a deadlock. Deadlock when either one house is rejecting or amending a bill or not acting a bill for 6 months. This joint sitting of the two houses, the will of the Lok Sabha prevails. But this joint sitting cannot happen in case of a money bill, in case of a constitutional amendment bill. Can happen in case of an ordinary bill, can happen in case of a finance bill, and then you will have to specify the reasons as well. Constitutional amendment bill is so important that it requires sanction of both the houses separately. Because if it's a joint sitting, then the will of the Lok Sabha prevails. Then Rajya Sabha will lose its voice. That is why there is no joint sitting. Money bill, there is no joint sitting because Rajya Sabha does not have a role, has an inferior role when it comes to a money bill. That's why there is no joint sitting. Mention this. This question was asked in 2017. Why it was asked in 2017? Because at that time it was argued that since we are not able to pass GST bill was pending for a long time. Some people suggested that let's have a joint sitting of the two houses. But then there were elaborate articles in Indian Express, the Hindu newspaper, which said you can't have joint sitting for GST because GST is a constitutional amendment bill. And a constitutional amendment bill has to be passed by both houses of the parliament separately. To what extent is Article 370 of Indian Constitution bearing marginal note, temporary provision with respect to state of Jammu and Kashmir temporary? Discuss the future prospects of this provision in the context of Indian polity, because that was the year when a petition was filed in the court challenging the validity of Article 35 capital E. Current affairs. Under what circumstances can financial emergency be proclaimed by the President of India? What consequences follow when such a declaration remains in force? Under Article 360 of the Constitution, if the President is satisfied when the financial stability or the credit of the country or any part of the territory is threatened, then the President may proclaim national emergency. And national emergency continues till the time it is revoked by the President of India. National emergency shall have to be approved by both houses of the parliament within 2 months of its proclamation by simple majority. Although national financial emergency has never been imposed in this country, but these are the following likely things that will follow after the proclamation of financial emergency. The states will be advised to observe the canons of financial propriety. The states will be asked to reserve bills, money bills, and budget for the consideration of the president. Salaries of constitutional functionaries and government employees can be reduced during financial emergency. This is likely to happen when a financial emergency is declared. Problem solved. Answer the question. Answer the question and meet tomorrow, 7 a.m. and let's discuss Schedule 9, then Schedule 10, and then we will have an elaborate discussion on center-state relations. Can we have joint sitting in constitutional amendment bills? No. What will be the agenda for tomorrow's class? That's what I said. 9 schedule, 10 schedule, center-state relations. Okay then, bye-bye, take care, have a great day.